I seek a loss of indulgence in mentioning item number 10 of part 2.
Yes.
This, my lord, I have taken the consent of the other party. If this may be taken up after vacation, after the ensuing vacation.
After the vacations? First, next week is the vacation now. Yes.
Item number 10.
Mr. Victor L. Rajde, learned counsel for the petitioner, has prayed for adjournment of the matter with the consent from the other side. In view of the above, list after the ensuing vacations. Yes.
Deeply obliged.
Motion item 1.
May it please your lordship. My lord, this case is pertaining to the destruction of my landed property due to the construction of widening of NH 54 along the Tuipang district, Lunglei district, my lord. I was claimed that my property was outside the ROW, so I was not included in the 3G
Yes.
notification dated 7/3/2019. And now my property is, my land has been cut through by the respondent authority, and now my 2 residential buildings were damaged, my lord. Hence, at this stage, my lord, my prayer is that let notice be issued and
Okay, we'll issue notice. So you're saying that your residential house has been destroyed, building?
yes, my lord.
So here it says, instructed her to demolish her residential building within 4 days
Yes.
from 16/06/2020.
Yes.
That's way back in 2020.
Yes, my lord.
So you have come to this court in 2025.
Yes. I have submitted several complaints, my lord,
Okay.
to the even to the respondent authority, my lord. Subsequent to my complaint, in pursuance to my complaint, spot verification was also done by the respondent number 5. But no, even though spot verification was conducted, no other
Okay.
outcome has been.
Because this is, I'm just wondering, this is way back in 2020, so your residential building. So after that, you have submitted several
Yes, madam.
complaints. Okay. Okay. I heard Mr. Lalbiaknungan Namte, learned counsel for the petitioner, who has filed the instant writ petition under Article 226 of the Constitution of India for the issuance of the appropriate writ or order to the instead of order or direction, okay, to the respondents on the ground that the petitioner, being a resident of which place? Tuipang.
Pupui village, and my
Pupui
property
village.
and my damaged
Okay.
property is at Troipui North 1.
So if you belong to Pupui village and your residential building where you're residing,
Yes, my original residence is at Pupui, but due to work
okay,
and
okay, just cancel that. Who submits that her residential building has been demolished. Now it's demolished, isn't
Yes,
it?
madam.
Has been demolished due to the upgradation of the NH-54 within brackets Aizon-Tuipang within Lunglei district. Full stop. The residential building of the petitioner is covered by her landed property bearing LSC number 209-101/01/1 of 2005, located at Toi Pui, N-Roman 1, Lungde District. Full stop. The learned counsel for the petitioner submitted that the petitioner was not included in the capital G award published by respondent number 5 dated 07/03/2019, since her landed property was claimed, since his landed property was claimed to be outside the ROW with all capital within brackets right of way, full stop. The learned counsel submits that after the demolition of the residential building of the petitioner, the petitioner had submitted several complaints to the respondents, and a spot verification was conducted on 26-30th July 2020, and thereafter other spot verifications were again conducted on on 10-25th March 2021. However, since no relief was granted to the petitioner had submitted complaints on 29/08/2023 and 21/10/2024 to the respondent number 5. Since no relief has been granted to the petitioner till date, the instant writ petition has been filed. Notice be issued to the respondents. Yes, Ms. Baby is also accepts notice on behalf of Ms. Azaram Sangpui, learned CGC for
Respondent number 1.
respondent number 1, and Mr. Samuel El Changte accepts. You are representing as the
Standing counsel.
learned standing counsel accepts notice on behalf of respondents number. Yes, learned counsel. Learned counsel for respondents number
2, ma.
2 accepts notice. Yes, state government, are they made a party here?
No, my lord, only Kala.
Accepts notice, full stop.
My lord, one more thing is that for the respondent number 3 and 4, if I may be allowed to serve notice through Dusty, my lord, because their camp, they have seized their camp. I was informed later on that they have seized their camp, and I personally obtained their representative phone number. So I may be allowed to serve
3 and
notice
4.
3 and 4. But
Toi Pui. So they're no longer residing at Toi Pui, is
yes,
it?
yes, my lord.
No, then you have to find out where's the state.
Yes, I have collected their representative phone number at Aizol. I can be, if I may be allowed to serve a notice to Dusty, my lord, it may be of much more convenience. In addition to the notice to,
Okay, issue notice to respondents number 3 and 4 to registered post with AD within 3 working days, returnable by 3 weeks. Full stop. The learned counsel for the petitioner submits that he has been verbally informed that the respondents number 3 and 4 may have shifted their camp, and therefore he pray that he may be also allowed to serve notice to respondents number 3 and 4 through dusty mode. Considering the nature of the submission made by the learned counsel for the petitioner is also allowed to take steps for service of notice upon respondents number 3 and 4 through dusty mode. Affidavit to that effect is to be filed accordingly. Full stop. Okay. Now make sure the notice is served to the correct persons,
Yes,
not
madam.
just some representative or some authority, whoever receives. Okay.
Yes, madam.
This after 3 weeks. Meanwhile, requisite copies of the writ petition to be duly furnished to the learned counsels for respondent number 1 and 2. Yes.
Deeply obliged, madam.
Item 2. May I please your lordship. My lord, the petitioners herein were government primary school teachers who had, the respondents had denied them the counting of promotion to selection grade. In fact, my lord, the state respondents, by notification dated 9/9/1975, had transferred those government lower primary school within the Seha district under the erstwhile Lakher District Council, which is now known as Mara Autonomous District Council. On being transferred those schools, my lord, there was a terms and conditions which stated that the existing teachers therein shall be on deputation under the MADC. But
On deputation.
on deputation, my lord.
Okay.
And all the benefits, they shall be entitled to all benefits as the state government employees. And another condition is that when vacancy arose due to death or retirement, the MADC can fill up that vacancy subject to approval of the state government. Accordingly, my lord, the petitioners were appointed during the year between 1991 to 2001. Subsequently, their appointment was approved and confirmed by the state respondents. So, when the seniors who are similarly situated were retired, they have claimed for pensional benefits under the state, which was denied. That they have approached this court filing two writ petitions, which was already allowed, and this court had already held that the
Oh, so you're saying this, okay. So here you're saying that this is a covered matter?
no, my lord, no, my lord.
Then?
What I mean to say is that it was already held that these similarly situated employees were entitled to get their pension benefits under the state government, meaning thereby they were the employees of the state government. Now, the petitioners they were claiming promotion to selection grade, but this was denied to them, my lord. Others similarly situated who were their seniors, they have been granted the promotion to selection grade.
So you're saying that this is covered because previously also similar situated persons, is it?
Those, yes, my lord, but those who were granted promotion to selection grade is not by virtue of the court judgment.
Okay.
The court had interfered only in
Okay,
respect of
this
pensionary
is for
benefits.
to get your pensionary benefits.
No, my lord.
Then?
For promotion to selection grade,
Okay, for promotion to, okay, then the court judgment of the court is for
pensionary benefits.
pensionary benefits, okay.
Now the state have said that they were not the employees of the state government.
So they can't be promoted?
Yes, my lord. They have been denied.
Okay, heard, Mr. Let's see the order, the appointment order. Where is it? And the order denying them their promotion?
My lord, if I may take your lordship to page number 43. 43. Annexus 6,
43.
page number 43. This is office order dated 5th October 2005. This is the approval of the state government. Approval of their appointments. If your lordship may come to page number 46 onwards, I have marked the petitioners.
Okay,
Page number
so-
46, this is the approval.
But so many of them have been appointed.
Yes, my
isn't
lord.
it? So what about the others, those who have not come before the court?
They have already enjoyed the promotion, my lord. Now they have retired.
They have retired. Okay, when they were promoted, okay.
Now when the turn
So
of
when
the...
they were promoted,
Yes, my lord.
they were promoted by the state government.
Yes,
is
my
it?
lord. Yes, my lord.
Okay. And that enjoyed their pensionary benefits from the state government.
Yes, my lord. As well as the promotion to
So
selection grade.
okay, so now the present petitioners are also similarly situated.
Yes, my lord.
And they also want their promotion,
Yes, my lord.
which has been
Yes, ma'am.
denied. Okay, where's the order denying them there? On what grounds? Let's see.
Page number 88. NSR 14, page number 88.
What are the grounds? Just read.
With reference to your letter such and such on the above mentioned subject, I am sending back herewith service books and connected documents in respect of 71 primary school teachers for upgradation to selection grade, as these primary school teachers are not the employees of school education department. And
But their seniors were
yes, my lord.
promoted.
Yes, my lord. If I may take a lordship to the following page, my lord. The proposal of the MADC to the state government, NSF 15. I have the English translated version in page number 92. Page number 92. Have you got it, my lord?
Yes.
To the director and so, respected sir, with reference to the subject indicated above, I would like to request for granting promotion to the government primary school teachers who are on deputation under the MADC, since they are now eligible for granting promotion in terms of the recruitment rules of 2016. Propose this for granting promotion to senior selection grade. Here are the petitions, my lord, the list. And coming to page number 94. The service book and SCR of the above mentioned government primary school teachers were maintained by the School Education Department, MADC. They have submitted their property return through online as per instruction. Since all of their service book and SCR are quite bulky for transmitting it physically, the School Education Screening Board under the MADC had carefully examined the service book and SCR and the given list were found to be correct. Thus, we earnestly request for approval of the screening already done by the MADC and thereby grant approval with giving liberty to the School Education Department MADC to publish their promotion order. There are presently 70 government primary school teachers who are on deputation under MADC and have not been promoted to the senior selection grade. However, there are 10 teachers omitted since there are incomplete documents while screened by the screening board. We are giving our best of effort to settle their service book and SCR, and they were screened. And after they were screened again by the screening board, an application is submitted for their promotion. This is letter dated 10/9/2024, but the respondents remain adamant and they have not taken any steps. till
Okay,
date.
we'll issue notice.
Yes, my lord.
Let's see. Yes, heard Mr. Victor L. Rajay, learned counsel for the petitioner who has filed the instant writ petition under Article 226 of the Constitution of India for the issuance of the appropriate writ or direction to the respondents by sealing the order dated where's the order
Page
refusing
number
the-
88, my lord. Page number 88, the impugned.
Assailing the order dated 04/06/2020, wherein the upgradation of the petitioners / primary school teachers to selection grade was rejected on the grounds that they are not the employees of school education department. Stop. The learned counsel for the petitioner submits that the petitioners, who are the government primary school teachers, were appointed between 1991 and 2001 and were working under the Mara Autonomous District Council within brackets MADC, wherein their appointment was approved and confirmed by the state respondents. Full stop. As per the notification issued by the state respondents dated 1975, the said petitioners were working under the Mara Autonomous District Council on deputation. However, when they were due for promotion to the next higher grade, their promotion was denied by the said impugned office order dated so and so, the same order. Okay, full stop. Aggrieved, the learned counsels have aggrieved, the petitioners have approached the court by way of a writ petition for their promotion, which okay, for the promotion, full stop. Just make it short, promotion, full stop. Issue notice to the respondents. Ms. Lalnundlui, learned government advocate, accepts notice on behalf of the state respondents. Any other?
All state.
Okay, with the respondent, in full stop, requisite copies of the writ petition to be duly furnished to the learned government advocate, list after 3 weeks.
Yes, ma'am. Give the evidence.
Admission, item 3.
Before list after 3 weeks, no need to issue formal notice.
Lordship, I'm appearing on behalf of respondent number 6.
Yes,
Lordship, may I seek another 3 weeks time for filing counter affidavit?
respondent number 6 is
Duly impleaded respondent, Ministry of Finance.
Ministry of Finance.
Yes, my lord.
Have you made any attempt to contact them?
Yes, my lord.
My lord, they were impleaded on 22/2025.
Anyway, we'll give them, so pursue the matter, okay, make the effort to contact them over phone, find out what's going on. Ms. Emily L. Sangte, learned counsel for the petitioner, is present, along with Ms. Baby so-and-so, learned counsel, appearing on behalf of her senior, Ms. Zairem Sangpui, learned CGC, and Ms. Lalnun Lui, learned government advocate for the state respondents. Full stop. The learned counsel. No, instead of that, just say that Ms. Baby L. Ghazwali, learned counsel, has prayed for further time to file their counter affidavit in view of the above list after 3 weeks.
Item 4.
May it please your lordship.
Yes.
My lord, the
What is
instant
the
case,
stage?
yes. My lord, the instant case challenges the order dated 7/06/2007, wherein the petitioner was dismissed from service, and later his appeal was also dismissed by the order dated 30/11/2007. And my lord, the petitioner has prayed for back wages, including all the pensionary benefits as per in seniority with and the
What's wrong
same
with the
grade.
inquiry?
Yes, my lord.
What's wrong with the inquiry or the
Inquiry-
steps taken by the disciplinary authorities?
My lord, the brief facts, if I may.
See, because this court doesn't really look into, unless some gross illegality or
Yes.
has been committed. So just in 1 or 2 lines, what's wrong with the disciplinary proceedings?
My lord, memorandum was issued to the respondent, and thereafter inquiry officer was appointed, and an inquiry report was duly furnished before the disciplinary authority. However, that appointment of the inquiry officer as well as the inquiry report was not furnished to the petitioner hearing.
Okay, so copies were not received.
Yes, and it was only after a series of RTI applications and an RTI appeal before the Chief Information Commission that this inquiry report was furnished to the petitioner only in the year 2021, whereas the inquiry report itself was in 2007. And that he was due to the inquiry report submitted by the inquiry officer, he was dismissed from service.
Okay, and you were not given a chance to reply to the articles of charge made out against you, is it?
I was not informed.
You were not informed, so
Yes.
you had
Yes.
not given.
Even though I have applied for a copy of the inquiry report, that was not furnished to me. And after dismissal, even after
So,
dismissal,
the procedure demands that you should also be heard.
yes.
Yes, so, counsel for the, from his submission, it appears black and white. Okay, he has not been given a chance of being heard, then he has to be given.
He has duly been given chance, my lordship.
Okay, so
And
you're saying he has been given.
Yes.
Then we will, this thing, admit the matter and list it for hearing, isn't it?
My lord, we are ready to go for disposal at this stage, if your lordship permits.
Too many matters are filed here, it becomes difficult. So we'll list it for proper
My lord,
hearing.
my lord.
Isn't it? Because it is at its admission
My lord.
stage,
My lord.
and these matters need to be heard,
My lord.
isn't it? Heard Mr. Tila Zekima, learned counsel for the petitioner, along
My
with
lord,
Mr. C.
I am the legal.
Okay, legal aid counsel for the petitioner, along with Mr. C. Zoram Thana, learned counsel for the respondents. On hearing the submissions made by the learned counsels for both the parties, this court finds that this matter deserves to be fully heard. In view of the above, the writ petition is admitted and to be listed for hearing. When do you want it? After 1 week, 2 weeks?
1 week, my lord.
1 week,
After vacation.
Oh, after 1 week,
Duly obliged.
yes.
Item 5.
Yes, so pleadings are complete?
Yes, Lordship, it's completed. And in fact, we are prepared for admission hearing. Even Lanet AG is appearing online also.
Yes, yes, okay. So pleadings are complete? Then we can list it for admission hearing in the next date, immediately after the vacations. Isn't it?
If your Lordship can
Because what
hear,
is the situation now?
my Lord, it's still, that the order still stand, that
Okay, still
dissolution,
stands,
yes, it still
this-
stands, yes.
So it's now, and the order is for 6 months?
Yes,
6 months.
And what is the date of the order?
7/7.
7/7 for 6 months. So there's still time. We'll list it immediately after the this thing
My lord,
vacation.
can I-
We can fix a date.
Can I have dates?
Okay, yes.
October 14 or 13?
13, 14, my lord, I am not available. I am in Supreme Court, my lord.
14?
Okay, so
13th
we'll
and
fix a
14th,
date.
13th and 14th. I am in Supreme Court.
My lord, any date on
any
second
date-
week, on
any date before
13,
that, my lord.
between 13 to 17, any date, when AG is available?
When will you be available?
Before that also we can do it. Lordship.
After the vacations.
It's holiday.
After the, when it is,
So vacation is up to the 3rd. So 6, 7, 8,
Third.
9.
we can do it on 8th or 9th.
My lord, 8 and 9, I have arbitration in Guwahati, it's already fixed. What about on 6?
On 6th, immediately after opening. I can't hear you. Yes.
My lord,
Have some
can we have
personal
between
problem, my lord,
13 to 17, any date on 13 to 17?
16th.
Yes, fine.
16th. Okay.
My lord, I was ready to argue the matter. If my learned friend is ready to argue the matter today, I can argue the matter today also. It will not take much of time.
Okay, since pleading is complete, both the parties are present. Let's hear the matter. Yes.
Yes. So, my lord, can I start?
Yes.
My lord, this matter pertains to dissolutions of Chakma Autonomous District Council, that is which we challenge. My lord, allow me, a very brief fact is there. So, if you come straight to Annexure 1, so it starts from
So basically, it's challenging the order
of the governor.
of the governor, wherein he had dissolved. Let's see the order.
My lord, it starts at 44, page number 44.
And then we'll see the reason, page 44, the
44.
reason for dissolution
reason is
also will be
political
given there,
instability.
then we can discuss from there, isn't it?
Yes.
Wait, page 44. Yes, 07 7/20/25. Let's
Allow
see
me-
the order. It must have given the reason for
Yes.
passing the order.
Only one reason. May I kindly read?
Yes.
Whereas Mr. Molin Kumar Chakma was removed through a no confidence motion from the post of Chief Executive Member Chakma Autonomous District Councils on special sitting of the 11th Chakma Autonomous District Councils on 16/6/2025. And whereas upon the removal of Sri Molin Kumar Chakma as Chief Executive Member CEM, Mr. Sri Lakhan Chakma's state claim to be the third CEM of the 11th CADC, and whereas the Honorable Governor is of firm opinion that the constant political instability, this is the reason,
This is
political
the reason.
instability is extremely detrimental for the CADC and is certainly not what is intended by the sixth schedule to the constitution in India, which envisions the effective administration of the tribal areas for the good of the people, and whereas opinion of the councils was obtained, and whereas as provided under para 16.2 of the sixth schedule, the Honorable Governor is satisfied that administrations of CIDC cannot be carried on in accordance with the provisions of the sixth schedule. Now, therefore, in exercise of the power conferred by para 16.2, read with para 20 BB of the sixth schedule to the Constitution of India, the Governor is pleased to assume to himself all functions or powers vested in or exercisable by Chakma Autonomous District Council. Further, the Governor of Mizoram is pleased to declare that such functions or powers shall be exercised by Deputy Commissioner Longklai on his behalf with immediate effect for a period of 6 months or until further orders. Well, basically, I have 5 grounds. Before I go further, allow me just to point out. One is that the petitioner having absolute majority are entitled to form government as provided under Rule 22 of Chakma Autonomous District Council. That is my first point. Number 2, this impugn notification has no legal sanctity. It's lack of constitutional authority.
Okay.
Number 3, the governor has acted unreasonably, discriminatorily in violations of Article 14. And number 4, the governor acted in contraventions of the advice of the councils of ministers.
What? Here it says that on the advice of the Council
Now,
of
acted
Ministers.
contrary to the advice of the councils of ministers.
Okay.
Because the council of ministers advised him to give a chance to stake claim, to form a government, opportunity to be given to the petitioners. And number 5, in view of the decisions of many Supreme Court decisions in many judgments, including recently you passed it, Vizir Sangha case, that it is the constitutional mandate to conduct floor tests. Recently, your Lordship also passed. These are my basic, though I have some other points. So just,
Okay.
So, my lord, before I start, allow me the very short brief fact. So, my lord, this case is. So, I started this. The story started from 5th June 2025. This. So here 14 members, MDC members, so submitted request to conduct special meeting on 5th June by 14 members. If you kindly see page number 29.
29.
Yes. So these are 14 members. They consist of 2/3 of majority in the existing 19 members. So they requested to the chairman to conduct a special meeting. So in view of this letter, requisition letter, the chairman issued notification on the same day. So special meeting has to be conducted on 16 June.
Where's the 16 June?
16 June, it is notification, page number 21, annexes 2.
21.
31.
31.
Annexure 2. So here, special meeting has to be convened on 16 June. So I'll just come straight. What happened on 16 June? So 16 June, notice of no confident motion was issued. So then that incumbent Artwell CEM lost the majority on 16. And this in this special assembly at 10:30 a.m. So then new ZPM legislature party was formed on 16 June itself.
New party was formed on 16.
No, that is
what
ZPM
happened?
legislature party.
Huh.
If you kindly see 34, page number 34.
So this is what 34 is what happened on 16 June, is it?
16 June, he was removed. That the Answell CM was
Okay,
removed.
so on 16 June, page 34 happened, is it?
Yes.
What
So
is page
petitioner
34?
number 1 was elected as the leader of the PM legislature party.
So page 34, in page 34, who is this leader?
That
Lakhan
petitioner number 1. Yes,
Lakhan Chakma
yes,
was
petitioner number
selected.
1.
Lakhan Chakma is the petitioner?
Number 1.
Okay.
So the rest of the one who supported him are in the petition number 2 to 415.
Petitioner number 1 was selected.
Yes.
Previously, who was it?
Mohin
Previously-
Kumar Chakma, that he's not there. He's not there in the petition, in the case.
Okay.
He lost the majority.
He's not the respondent,
He
he's
has not
nothing.
at all. Because, see, they have absolute majority.
Who has?
This
The
ZPM legislature
petitioner, the
party.
petitioner.
Yes, petitioners. See, my lord, if you
So
see,
the petitioner has absolute majority. You found that out on
Well, 35.
16 June.
yes, my lord,
You
kindly
found
see page,
out that on 16 June only, huh?
kindly page number 35. These are all
35.
who supported.
So
Yes.
35. So because of 35, 34, you have the majority,
Yes, my
isn't
lord,
it?
remember that it is 20 members MDC, total members of the MDC is 20. Out of 20
members,
we
you
have 16 majority.
Okay.
Interestingly, that the by-election was conducted recently. We can see from the counter affidavit filed by respondent number 4 also. Now we have become
Who is respondent number 4?
CIDC,
CADC is represented today?
Mary.
I'm representing
You are the counsel?
CIDC. Yes, my lord.
You are ready for hearing?
Yes, my lord.
So my lord, in their counter affidavit, they submitted that. Now we have one more member. Now we have become 17. Absolute majority.
Out of 20,
20.
petitioner has 16 majority.
Now 17.
Now 17, when? When was it 17?
When election,
No,
you'll
you
see
tell
in
me,
their
you tell me.
affidavit.
Where?
My lord, by-election was held on 23/7/2025.
We are talking about 16 election, 16/6. 16/6 he has this. On 16/6 he has
My lord,
16 majority, isn't it?
Yes.
Then when was it 17? It increased to 17 on?
My lord, in their counter affidavit, they have enclosed.
But you should know, you read the counter.
Yeah, I have the copy here, my lord. Annexure number 2.
17 on, 17 numbers on.
My lord, that on 8 August, certificate of election was issued on 8 August 2025 to one Mr. Dinesh Moy Chakma.
To 2025.
Yes, 8 August 2025 from ZPM party. Now we have 17 members.
Oh. So, but the order was, the impugned order is when?
7-7.
7-7.
This is
so
after
plus-
filing this one.
So leave it, the impugned order, so you don't talk about this, we are talking about only the order, impugned
Yes.
order. That was
But this-
before 8-8, isn't it?
7-7.
So
Yes.
it is before the increase of 17 numbers.
Yes.
So we don't have to look into this, we have
Yes.
to see the order 7-7.
That's
Don't confuse the court.
yes. No, just to appraise the court.
No, I'm not interested in all that, I'm just looking at the impugned order, Yes.
So then after that, so we stake claim. So then they, very interestingly, this annexure number 10,
What is annexure number 10?
page number 42.
Annexure number 10 is?
Opinion of the councils of ministers.
Okay, Council of Ministers. So one of your points was, it was, the decision of the governor was against the opinion
Yes.
of the Council of
Yes.
Ministers.
Yes.
So what is the opinion?
See, here that the decisions of the governor, allow me to read on.
The annexure 10,
Yes.
please read.
Additional Secretary, Political and Cabinet Department may please find enclosed herewith a copy of Honorable Governor D.O. letter dated such and such, addressed to the Honorable Chief Minister, wherein it is stated that the Honorable Governor wishes to assume to himself all of the function vested in the Chakma Autonomous District Council under Para 16.2 of the 6th Schedule, copy of such and such, due to political instability. In order to invoke this provision, consultation of the Councils of Ministers is required under paragraph 20 BB, and therefore may take action he considered necessary in his discretion. Commissioner and Secretary to the Chief Minister has verbally conveyed instruction of the Honorable Chief Minister that has decisions of the Councils of Ministers be obtained by way of circulation due to urgency and confidentiality of the matter. She is therefore requested to kindly take necessary action for placing the matter before Councils of Ministers by way of circulation. And the next one is the decision of the Councils of Ministers. Subject: proposal for obtaining opinion of the Councils of Ministers for impositions of governor rule within the Chakma Autonomous District Council. As per provision contained in Rule 15 of the Government of Mizoram, Transactions of Business Rules 2014 as amended from time to time, the above proposals of district councils as Minority Affairs Department was circulated among the members of the Councils of Ministers for opinion. The Councils of Ministers is of the opinion that the new claimant for the formations of a new councils be afforded an opportunity by the governor. However, the Council of Ministers is willing to accept any decision made by the Honorable Governor, as it is discretionary power of the governor to take action as he considers necessary. Here, the Councils of Ministers is the opinion that the new claimant for formations of a new government be afforded an opportunity by the governor. So, to give opportunity to form a government.
But there's a however, big
Yeah,
however.
however, my lord, that is not the point. This is the query. This is something like you applied RTI Act. So in the last para, it's always written that if you're not aggrieved, you may go to appeal authority or something like you invite for a dinner.
Anyway, so
Yes, if you're not,
according to you, it was
they
this,
acted in contrary to this decision. So this is the fact. Then it comes the impugn notification. This is very brief fact. So my lord, my point to elaborate first point, the petitioner having absolute majority in view of Rules 22 of Chakma Autonomous District Council 2002, my lord, that CRDC CCB rules will be required.
Yes.
My lord, it is at 14, page number 40.
Page number?
14. Rule 22. Lordship, are we there?
No, not yet.
Formation of
Oh, wait,
executive
rule
committee.
number 22.
22. Chapter 5.
Yes,
So, my lord, it is admitted.
it's page number 22,
Yes,
rule number 22.
Rule number 22. In my book, it is page number 14.
But we are not on the same
my dear
page,
Lordship,
okay?
yes.
Not the same book, huh?
But you're in chapter 5, Your Lordship?
Yes, yes, rule number 22.
Yes. May I read, Your Lordship?
Yes, please.
There shall be an executive committee of the district council with a chief executive member at the head and 5 other members of executive members to exercise the function herein after specified. And rule number 22 is my point. The executive committee shall be formed by the largest legislature party having a majority of elected member in the district council. The leader elected by such legislature party shall be appointed as chief executive member, provided that in case he is not an elected member, then unless such leader is elected as a member of district council within 6 months from the date of his appointment, as such, he shall cease to be the chief executive member and to continue as such. Lordship, even recently also, that Vizir Sanga case, you held this provision
I have
also.
decided
I will
many
be
cases,
relying also. My lord, this
anyway.
admitted position that out of 20 members, we have now 16 members. And you have seen in that also that those who support, when the petition number 1 stake claim to the governor were supported by that, it was not denied also. In their counter affidavit also, it was not denied. Since it is not specifically denied, it should be admitted that we have absolute majority. So then we...
So as per rule 22, you have the absolute majority and you should be appointed. That's your case?
Yes,
Okay.
this is my case.
Oh.
This is the rules, the only rules for administrations of CIDC, and we have been using this one, and there is no other rules. And so, my lord, this is my one point. And my lord, there is one judgment I don't need to reiterate, but I just want to refer that when there is a particular thing should be done, it should be done in a particular. I have furnished also. I'll not elaborate the judgment also, because
Just give the
since
citation. If you want to refer to this, then
Yes.
give the citation at least.
my lord, that is actually everyone we refer. Then I can furnish it also. I have.
Okay, so you don't want to refer, but I'll have
I
to
want
see
to
now what is it, then I'll have to find out what is that judgment you're referring to. So at least give the citation even if you don't read it.
Yes, my lord. Can I just citation is 1999, volume 8 SCC 200. That is where a power is given to do a certain things in a certain way. The thing must be done in that certain way, in that way only, not other way, because that judgment was derived from the very old judgment, Nazir Ahmed 1936. It is there in the citation of itself. And it was
1999 8 SCC 2000 2000.
266. 1999 volume 8 SCC 266.
Oh.
It has been followed in many judgments. Now, look, allow me to point out the latest one referred to.
Yes.
2021 volume 6 SCC 707. That judgment, when there is, yes, the power is given to do something and it has to be done in the particular. That is one of my first point. And my lord, then my second point is that in impugn notification, if you read that in impugn notification, it is very clear. it has been issued on the grounds of political instability. In fact, it is their grounds also, because there have been change, 2 times change in the political.
2 times change?
Yes. That is, it is very clear here, it's political instability. And, my lord, if I would like to take you to this one, the last para
Of what?
of the in-pin notification, page number 44.
44.
Yes. So, the preceding paragraph is due to political instability, and here now, therefore, in exercise of the power conferred by para 16(2), read with para 20(bb) of the 6th schedule to the Constitution, the governor of Mizoram is pleased to assume to himself. The provision relied by the governor in this notification is 16(2) and 20(bb). Because here my submission is that the governor has the power to declare governor or whatever, only which has been specifically mentioned in 20(bb). If you kindly see 6th schedule,
20BB.
20(bb).
So he has the power under 20BB, that you admit.
Yes, but in 20B, my point is that there is no provision to declare on the grounds of political instability. Specifically mentioned, there are some paragraphs specifically mentioned.
Okay.
And if you kindly go to 312 of the 6th schedule.
Wait. Okay, under what grounds can the governor pronounce governor's
Yes.
rule under Article 20BB? That
Yes,
is what
yes.
we're going to look into. Huh?
Yes. Here the last para, it is there
Wait. Last para.
in page number 312. Here there are the lists in which the
20B.
governor can discharge his function.
20B, isn't it?
20BB. Because this is the provision in the in-pin notification, this has been referred, 20BB.
Okay. Read 20BB.
Yes. So 20BB, these are the governor in discharge of his function under sub-para, paragraph 2 and 3 of paragraph 1. This is one list. If you kindly go to the 6th schedule, para 1, sub-para 2 and 3 and para 1, it is there. But there is no such political instability.
And para 1, 2 and 3.
Yes.
Para 1, 2 and
2
3.
and 3.
Yes.
Yes, that's the very first page. Para 1 is in regard to scheduled tribe. Then regarding division of the area. And number 2 is that inclusion, exclusion of the constituency and creating an autonomous district such and such. And number 2 is, because here only para 2 and 3 of para 1, wherein the governor can discharge his function, can exercise his discretionary power. If you
Okay,
look
and then,
back again, yes, sub para 1 and 7 of para 2. If you, yes, para 2, sub para 2, in respect of 1 and 7 only, the governor
You
can
should have highlighted the points, isn't it?
Yes.
Anyways. 1 and 2 and 3.
Yes.
2 and 3. Then
Then in para 3, only,
para 3,
only in respect of para 3, that is in respect of to make
Constitution of District Courts. Para 3 is power of District Council.
yes,
Is it?
yes,
And this para 3.
and para 4 in respect of para 4, in respect only in sub para 4.
Para 3 is sub para 3.
Yes.
Sub para 3.
Yes,
Wait, para 3, sub para 3 will be where? All laws
Yes.
meet under this.
Take
So
number
regarding the
294.
laws,
Yes.
isn't it?
yes.
Then
Then para 4,
sub para 4 of para 4.
4 only.
What is sub para 4? The regional council or district council, as the case may be.
Yes,
This is regarding rules, regulations.
yes.
Huh.
And para 5, there is no such power given in para 6.
Para 5. Para 6 is
Yeah,
what?
para 6 in sub para 1. It's regarding establishment of primary school and dispensary market and ferries, road, transport and all. There is no such political instability wherein the governor is empowered.
Okay, what about 16.2?
16.2 is general provision. Yeah, my lord.
20 BB and 16.2.
Yeah, my lord, just before I go, in all the list, there is no such power being given to governor to declare this of on the grounds of political instability. This is my submission. If it is there, my
Under
opinion
20
council
BB.
can-
Under 20 BB, nothing.
Yes, yes. And his 16 is important.
What about 16.2?
16.2 is important.
What is 16.2?
My lord, it's page number 312. Because in 16.2, the governor has been empowered in respect of what we have stated in those specific paragraphs. And in
Wait, 16.2 is where in this
313,
313.
just below that one, just next to that page.
See, I think we should look at the constitution. You've given me this because maybe to make it easier, you have
This, I printed out
just a
from the
sec.
constitution.
Yeah, you print it out. Thinking it will be easier.
313 is 16.2.
Page 313. (20B). Page 313. Just find out
Yes.
what is this. No.
Yes.
Yes, God Master, look this side. Tell him to mark. (16.2). You're saying this is 16.2, but where's the 16?
And just above that, it starts from
2.
307.
Wait. Okay, yes.
My lord, allow me to read from 16. It's a,
Yes, 16.2.
yes. Can I read 61 also?
Okay,
Which is
yes.
continuing. Dissolution of a district or regional council. The governor may, on recommendations of a commission appointed under paragraph 14 of this schedule by public notification or the dissolution of a district or regional council. Number 1, direct that a fresh general election shall be held immediately for the reconstitutions of the council, or B, subject to the previous approval of the legislatures of the state, assume the administrations of the area under the authority of such councils himself, or place administration of such area under commissions appointed under the said paragraph or any other body considered suitable for him for a period not exceeding 12 months, provided that when an order under clause 1 of this paragraph has been made, the governor may take the actions referred to in clause number B of this paragraph with regard to the administrations of the area in questions pending the reconstitutions of the councils on a fresh general election, provided further that no action shall be taken under clause B of this paragraph without giving the district or regional councils, as the case may be, an opportunity of placing its view before the councils of the state. This is B, is what the point the governor relied. If any time the governor is satisfied that a situation has arisen in which the administrations of an autonomous district councils or regions cannot be carried on in accordance with the provisions of this schedule, he may, by notification, assume to himself all or any of the functions or power vested in or exercisable by the district councils, or as the case may be, the regional councils, and declare that such functions or powers shall be exercisable by such person or authority as he may specify in this behalf, for a period not exceeding 6 months, provided that the governor may by a further order or the orders extend the operations of the initial order by a period of not exceeding 6 months on each occasion. Every order made under sub-rule 2 of this paragraph, with the reasons thereof, shall be laid before the legislatures of the state, and shall cease to operate at the expiry of 13 days from the date on which the state legislatures first sits after the issue of the order, unless before expiry of that period it has been approved by the state legislature. So here the point is simple, that it will be for 6 months. It has to be laid before the legislature, and it has to be approved by the legislatures. This is the thing. But what is important is that there are some lists, specific lists, wherein the governor can proclaim these governor rules, as we read one by one. So there is no contention on their part that this is the provision in which the governor can proclaim dissolve the exercise discretionary power. This is my point. So, my lord, I have one judgment.
Okay, let's say a judgment, because I'm not getting your point. The 16.2 is there, it's clear. Okay, we'll leave 20 BB, but 16.2, you have just read that. But you have a judgment, huh? Let's see
Yes,
the
yes.
authority.
My lord, my point is that in 20 BB,
20 BB, leave it, but 16.2, you have just read where the
Yes.
governor can exercise his
that will make it clear that the
discretionary power,
interpretation.
huh? So let's read the authority.
So, my lord, just before I start, that very brief fact of this case is that there is allegations of corruptions against CEM and some MDC members in autonomous district in Assam. So then there's action was taken, and the governor issued notification dissolving that their autonomous district council, and then they challenge it, and this is the case. And then the issue in this case is that the power of the governor in respect of that 6th schedule, particularly declaring in view of that 20 BB and 16.2 also. And my relevant portion is that it starts from 46 paras 46.
Yes.
The satisfactions of the governor under paragraph 16.2 of the 6th schedule, because all over Northeast, the 6 schedules is applicable. It's everyone's. It is applicable to all the autonomous district councils in the Northeast India. Then the satisfaction of the governor under para 16.2 of the 6th schedule is subjective satisfaction. Such satisfaction cannot be subject to scrutiny in light of the objective test. The parameters of the judicial scrutiny in a case like this are within narrow confines. It is also necessary to bear in mind the purpose contemplated in paragraph 16.2 of the 6th schedule and the connotations of the word is satisfied that a situation has arisen in which administrations of autonomous district councils or region cannot be carried out in accordance with the provisions of this schedule. And there some Supreme Court judgment has been taken. Para 47, Supreme Court had occasion to consider the scope of judicial review in regard to the action taken under Article 356 of this Constitution in case of State of Rajasthan versus Union of India, All India Report 1976, Supreme Court case, page number 136. Chief Justice in Para 63 of the judgment quoted that the following passage from Tagore Law Lectures on the Union and the State relation delivered by Mr. Setalvat. The constitution machinery in a state may fail to function in numerous ways. There may be political deadlock. The government of a state can also be regarded as not being carried out carrying out in accordance with the constitution, in cases where a ministry, although properly constituted, acts contrary to the provisions of the constitution or seeks to use its power for the purposes not authorized by the constitution. The governor attempts to call the ministry to order have failed. There could also be a failure of the constitutional machinery where the ministry fails to carry out the directives issued to it validly by the Union Executive, the exercise of its power under the Constitution. The learned CJ in Para 75 observed, if it is actually stated on behalf of the Union that an action was taken on a particular ground which really falls completely outside the purview of Article 3561, the proclamation will be vitiated, not because the satisfaction was challenged and called in question on any ground, but because it was admitted to be on matters outside Article 3561. Chandrachud J, as then he was in Para 124 of the judgment, stated that it is for the President to judge whether a situation of the particular description has arisen, necessitating the issuance of the proclamation for assumptions of all of any of the power mentioned in clause number 1, B and C of Article 3561. He is expected that ought to judge fairly, but we cannot sit in the judgment over his satisfactions for determining whether any other view of the situation is not reasonably possible, so long as the reason, if any, are disclosed, given for the action proposed or taken, bear a reasonable nexus with the exercise of the particular power. The satisfactions of the President must be treated as conclusive. It will then not be open to judicial scrutiny if, however, reasons given are wholly extraneous to the formations of the satisfaction, would be open to attack that it is vitiated by legal malafide. In the judgment of Bhagwavati J, in the Para 137, page number 1404, it was stated as follows: satisfactions of the governor that a situation has arisen in which the government of a state cannot be carried on in accordance with the provisions of the Constitution is a constituent precedent which must be fulfilled before the President can take action under Article 356, Clause 1. The learned judge stated in Para 144 as follows: we must make it clear that the constitutional jurisdictions of this court is confined only to saying whether the limits on the power conferred by the Constitution have been observed or there is transgressions of such limit. Here the only limit on the power of the President under Article 356 Clause 1 is that the President should be satisfied that a situation has arisen where the government of the state cannot be carried out in accordance with the provisions of the Constitution. The satisfactions of the President is a subjective one and cannot be tested by reference to any objective test. It is deliberately and advisedly subjective because the matter in respect to which he is to be satisfied is of such nature that its decision must be necessarily be left to the executive branch of the government. It cannot, therefore, by its very nature, be a fit subject matter for judicial determinations, and hence it is left to the subjective satisfaction of the central government, which is best in the position to decide. The court cannot in circumstances go into the questions of correctness, adequacy of the fact and circumstances on which satisfaction of the central government is based, but on till it is certain that if the satisfaction is malafide or is based on wholly extraneous and irrelevant grounds, the court would have jurisdiction to examine it, because in that case there would be no satisfactions of the President in regard to the matter in which he is required to be satisfied. The satisfaction of the President is a condition precedent to the exercise of power under 356 clause 1, and if it can be shown that there is no satisfaction of the President at all, the exercise of the power would be constitutionally invalid. My Lord, these are, because the power of the President and the Governor are one and same, only the difference is that the article. So,
Yes.
and my Lord, I'll just para 49, Fali Ali Judge restated in para 203, even if an issue is not justiciable, if the circumstances relied upon by the executive authority are absolutely extraneous and irrelevant, the courts have undoubtedly power to scrutinize such exercise of the
So
executive.
you have to show that the order is mala fide and based
Yes, my
on
Lord.
extraneous or
Yes, that is what
relevant
I'll come to
considerations.
ground number 3.
That is that's a reason why
Yeah,
you're
my Lord,
reading the
but-
judgment,
but-
isn't it?
yes, but my
Only
Lord-
on these conditions.
My Lord, allow me para 51. Here, if that's
51,
the crux of the case in this Assam Autonomous
Okay,
District Council.
51.
Here, this is the reason for setting aside of the governor order. The governor must be satisfied that a situation has arisen in which the administration of Autonomous District Council cannot be carried out in accordance with the provisions of the 6th schedule. This would mean breakdowns of the constitutional machinery in the Autonomous District. None of the ground relied on by the respondent have any nexus with any act violative of the provisions of the 6th schedule or user of its power by the councils for the purposes not authorized by the provisions of the 6th schedule or failure to carry out directives. If any issue to it validly, the state government in exercise of its power under 6th schedule of any other aspect arising under 6th schedule. Some of the grounds may indicate failure, but partially or fully in providing good governance or administration in the autonomous district, but it cannot be said that these grounds have any relevant or reasonable connection with the satisfactions of the governor that a situation has arisen in which the administrations of the administrative district cannot be carried on in accordance with the provisions of 6th schedule. The mind of the government is also clear from noted that 9/11/1992 of the Commissioner Secretary HAD indicating that the functions of the council was in an unhappy state of affair, and the cabinet decision dated 26/11/1992 and the cabinet discussed about the administration such and such and approve assumption the functions of the power of Karbi along district council by the government as per the provisions of para 16(2) of the 6th schedule to the constitution. It is clear that neither the secretary nor the government was satisfied that administration of the district by the council cannot be carried on in accordance with the provisions of the 6th schedule. The notification dated 27/11/1992 is therefore vitiated by non-applications of mind and unreasonableness. This is notification is that governor notification. The decision is one which has no reasonable person reasonably instructed in law can arrive in the light of the grounds as facts averted to. The notification dated 27/11 is therefore vitiated and it is based on matter outside paragraph 16(2) of the 6th schedule and is beyond the power of the governor. In innovations of para 16(2) of the 6th schedule for the reason extraneous to the purpose contemplated therein would amount to colorable exercise of power. Notification dated 27/11/1992 is therefore vitiated and cannot stand. And point answer in favor of the petitioner. Here, my lord, the order of the High Court is that in respect of the corruption case of that alleged to be committed by MDC members and all, since it is not in the list in 16(2), so the governor cannot make any declarations, cannot pass any order. It is outside the purview of the 6th schedule, and also it is coupled with extraneous and malefic intention, and it was set aside. My lord, my point again, let me just go back to 20 BB. Because 20 BB is the circumstances, the situations in which the governor can exercise jurisdiction, discretionary jurisdiction. My submission, my point is that here, if you read that notification 77, the reason why this notification was issued is that because of political instability. Because two times there have been a change of two governments. Because of that, there is political instability. Because that is my point, is that in 16.2, there has to be that the statement or any grounds in which the administration cannot be carried out in accordance with the provisions of 6th schedule as stated there. But in that notification, it is absent, totally absent. Because I have read specifically one by one. That is my point.
Okay. Then next.
And the next is that the governor has acted in violations of Article 14, acted unreasonably. My lord, my submission here is that I have mentioned in my grounds also, ground number C, they have not averted. There, if you see in Lai Autonomous District Council, there have been a change, 5 times change of the government in that the same 11 LADC, that very same 11, there have been 5 times change. And in that situation, the governor was very hurried to call for the government, for formations of the government, and also without conducting floor tests, without setting aside the orders of the appointment of the actual CEM, and directly pass an order to appoint the new CM. So that is, but in this case,
No, concentrate on this case.
yeah, no, but I have to submit that unreasonableness. But here in this case, only 2 times. It happens only, instability happened only 2 times.
You concentrate on this case.
Yeah, my lord.
So what happened?
But I have to
So
rely-
you're saying that this notification is unreasonable.
Yes.
Is that your point?
Yes,
Okay. Fine.
unreasonable. Well, but what I have stated is, in my petition also I have highlighted that is very valid. Because the actions of the government, it is malified, unwarranted, this is the point.
So, then next.
Yes, my lord, that is, and again, number 4 is that the governor acted in contraventions of the decisions of the advice of the councils of ministers.
That you have pointed out. No?
Yes, I have pointed out. I have read the lordship again.
So you have any authority on that
43.
point?
My lord, I don't have, but it is very clear, and I have Nabam Rabia, I have, and also
So you are relying on
yes,
citation
153.
153. What?
That Nabam, I have given.
What is the
court master.
citation?
Nabam Rabia versus Arunachal Legislative Assembly, 2016, Volume 8,
2016, Volume 8.
SCC
Oh,
1.
oh. Para 153.
Para, it starts from 153 till 155.
Yes.
Just only 3 para. May I read 153?
Yes.
Though the debate could be endless, yet we would consider it opposed to avert to the decision rendered by this court in Sardar case and Shamsher Singh case. Insofar as Sardar case is concerned, this court had held that the president or the governor, as the case may be, would pass an order only on his personal satisfactions. In the above case, this court, while examining the case of the employee under Article 311, Clause 2, more particularly under Provision C, thereof, recorded its conclusion in the manner expressed above. The same issue was placed before a 7-judge bench constituted to re-examine the position adopted in Sardar case. The position came to be reversed. The court in Shamsher Singh declared that whenever the Constitution required the satisfactions of the President or the Governor for the exercise of any power or functions, as for example under Article 120.
No, that point is you have already made. It should not be personal satisfaction. It has to be on the aid and advice of the Council of Ministers, isn't it?
Yes.
So that point you don't have to press upon. It has to be on the aid and advice. So
Yes.
your only point is that the Council of Ministers in the instant case, they have not aid and advised him to dissolve the,
Yes.
this thing. Okay,
Yes.
they have given a
To
opposite.
give opportunity to form the government is the
That
advice.
is, so that's your point.
Yes, because the law is very clear, yes.
So this, what you're reading, it's only that it is not the personal satisfaction of the
Yes.
governor, but Council of Ministers.
Yes,
On that
that's-
point, you don't
that's
have to
true.
press, you don't have to press that point, because we know it's clear.
Yes, it's clear. My lord, I'll not read, but
Ah.
I would like to draw your kind attention only, because this is Milai Licha, is specifically passed by 5 judges bench of the Constitution. The fact
It is
that-
not personal satisfaction
yes,
on
that
the
is
aid
true.
and advice.
Yeah, it has to follow act and advice of the councils of ministers.
So your point is that now in this case, the Council of Ministers had advised otherwise, but
Yes.
the governor had
Yes.
gone ahead anyways.
Yes, my
So
lord.
that's your point, huh?
My lord, at least I'll just
Oh,
cite
which
Yeah.
para?
the para only. Milai 2000,
Okay, yes, citation 2000,
citation is 2005 volume 2,
2005, huh?
SCC 92,
Para
para 12,
12, yes.
and para 14 and 15.
Same distinct principle?
Yes, same
Not
principle.
personal
The government has
satisfaction?
to act upon on the advice and of the
Yes.
councils of ministers.
Okay,
And
same.
18 is very relevant also
Huh,
here.
okay, so you can read one para if you,
Yes,
if you feel you require. Para 18,
yes, para 18.
what does it say? Same?
My lord.
Not personal satisfaction, but
Para,
has
yes,
to be.
the last one is that under the cabinet systems of government embodied in our constitution, the governor is the constitutional or former head of the state, and he exercises all his power and function conferred on him by and under the constitution on the aid and advice of his councils of minister. This is what I want to.
Yes.
But my lord, the fact is a bit different. Here is that in respect of this thing, terminations of nominated member, in this Milai Souza, nominated member can be terminated in all course because they enjoy that with the pleasures of the governor. But the point is that in this case,
Okay, the case concerns to termination of nominated
but in this
member.
case, the difference is that councils of minister advice was there, it was placed before him, and he acted in pursuance to the advice of the councils of minister. The difference is that this is autonomous district councils. The Supreme Court also took very serious these matters since it pertains to administrations of 6th schedule. But in this case, the difference is that though here aid and advice was shown, but it was not acted upon, in contrary that the governor had acted. Because here the law is very clear, he has to act and advise of the governor or the councils of minister. This is what my point.
Okay, para 18.
Yes. My lord, and then another point is that, my lord, recently there's judgment passed by you, because my prayer is not only setting aside this impugn notification 77. My prayer is also to direct the governor to conduct floor tests as per pursuant to the advice of the
Okay,
councils of
that's
ministers.
your prayer?
Yes, the last prayer.
Oh, okay.
So, my lord,
This is concerning your prayer.
yes, my lord, in this case also, it is very clear.
Floor test,
Here, Vizir Sangakis recently you pass it, and that very narrow margin, just by only 2 MDC in this case. And the governor passed this thing, impugn notification to invite to form a government.
So, okay, this is, so floor test was conducted here?
It was
for this
conducted,
case?
it was
So
conducted.
already
In
this,
in
so
compliance
no
of-
problem in lie autonomous,
Yes,
isn't
yes,
it?
yes, it should not be.
Every
Yes.
settled, huh?
Yes, it's settled. And my lord, I'll read, you know the fact of the case, it might still be fresh in your mind. I'll just read the last para, because my prayer is that to direct for floor test also.
Similar order, huh?
Yes, my lord, allow me to read 46, just only
46.
two para.
Okay.
The apex court in Chandra Kheslar Union of India has observed the following, passed the following order. During the course of hearing, we are satisfied that instance-sensitive and contentious issue raised on behalf of the petitioner can be resolved by the simple direction requiring that holdings of the floor test at the earliest. Holding the floor test would remove all possible ambiguities, would result in giving democratic process, require credibility. We therefore direct that all the prerequisite formalities for holding floor tests, including the formalities required to be completed by Election Commission, to be completed by 15/3/2017. We request the Governor of the State of Goa to ensure that a floor test is to be held on such and such. The only agenda for the day would be holding of a floor test to determine whether the Chief Minister administered the oath of office has supported the majority. The floor test shall be held on such and such as early as possible. This is your Lordship judgment passed by 17. Thus, considering the peculiar situation that has arisen in this instant case, this court finds that it is imperative for the writ petitioner to prove that he has the majority support in the House in terms of Rule number 21.5 of LADCCCB, Rules 2010, as stimulated in his appointment that such and such before he take up any executive decision. Accordingly, in view of the decisions of the Apex Court as discussed above, this court finds it appropriate to direct the petitioner to go through the floor test in terms of 21.5 of LADCCCB Rules 2010. Thus, all the stakeholders are to take immediate necessary steps to ensure that a floor test is held for the petitioner to prove that he has the required majority support of the House within the outer limit of 2 weeks from the date of receiving certified true copy of this order. So, my Lord, my
Similar order be passed.
Yes, my
That
point is
what
that
you're praying.
even their conduct rules are one and the same. That article, my first point is that being they having absolute majority, that article Rule 22 has come into play. Instead of that Rule 22, this is 21. It's everything is same. So then the petitioners are entitled to form the government, or at least to conduct, has to be given an opportunity to conduct floor tests in view upon the advice of the councils of ministers and by this order itself also. My last contention is that S.R. Bomaya, I have given the very last page, 434. Just this is the conclusion. The very brief fact is that Mr. Bomaya, Janata Dal Party was coming to power. It was toppled, and Bomaya was relief, and he was removed from the CEM. So he could not conduct floor tests. And the Maharashtra, the governor proclaimed governor rules, and then the same was challenged before High Court. He lost it, and again it came up before Supreme Court. And during that turbulent periods of time, it was passed by 9 judges bench. It's happened in many states. Nagaland, Arunachal, Meghalaya, in many states in India. Then where the governor proclaimed emergency. Here is the decision in para 434.
Para 434.
Because only proclamations of the governor rule, president's rule can be done with the aid and advice of the councils of ministers. This is the law. And Chief, my Lord, we may summarize our conclusion now. Article 356 of the Constitution confers a power upon the President to be exercised only where he is satisfied that a situation has arisen where the government of a state cannot be carried on in accordance with the provisions of the Constitution. Under our Constitution, the power is really that of the Union Councils of Ministers with the Prime Minister at its head. The satisfaction contemplated by the article is subjective in nature. My Lord, and here it is very clear that this is the councils of ministers and cabinet ministers in one and the same. And the reason why this notification was issued in their counter affidavit is that the minister.
Yes, it's okay. Facts of the case, I think I recollect.
Yes, because here the minister of respondent number 2, district council and that minority affairs, believe that there will be change of the government. And the governor, they specifically mentioned that the chief minister orally advised. Well, that is very pertinent here to submit here. This is my point. In the counter affidavit by the state respondent.
Okay, counter affidavit of state respondents.
I would like to read that.
Para?
My Lord, para 2. Page number 8.
State respondents will be 1, 2, 3, and 5,
Yes.
isn't it?
Yes.
Page number 8 of the
Yes.
counter.
Yes. So, may I read from?
It starts from which sentence?
Actually, I would like to read from that, the middle of page number 8.
Uh,
That is why that impugn notifications was issued. The Honorable Minister, may I read?
wait.
It's
where
1,
is
2,
the-
3, 4, 5, 6. From 13. Page number
Yes,
8.
yes. Okay, the Honorable Minister.
Yeah, the Honorable Minister, DC and MA, has mentioned in his concern that there may be another change of government since it is obvious that CIDC lacks political stability, and it would seem that either suspension or dissolution would be the best course of action. And again, this is the Honorable Chief Minister has also mentioned that the political behaviors of the members of CIDC are most unpredictable, and stability is a matter of serious concern. Though there is nothing in record and writing, this is one of the reasons that he proclaimed this emergency, believing that there will be political instability. Though I mentioned in my first ground that political instability is not the ground to proclaim dissolution, and this is the reason. As I have mentioned that, specifically I have mentioned that, if this is the reason, how can they proclaim that dissolutions of the CIDC?
Okay, but you're not really specifically denying that there could be political instability. That, for you, you're saying that there could be political instability, but political instability is not one of the grounds.
Yes.
That's your point.
Under 20 BB,
So you admit that there is political instability.
my lord, it is on record that 2 times there have been change of the government.
So there is political
Yeah,
instability.
but
Okay,
that
fine.
political instability cannot be the ground
But cannot
to
be a
dissolve
ground.
CIDC.
Yes. Anything else?
Then that I have not completed Bomaya case, Lordship. I'll continue Bomaya. And number 2,
Para 343 and which para?
for sub para 2, I have read 1 and point number 2. The power conferred by Article 356 upon the President is a conditions power. It is not absolute power. Existence of the material which may comprise or include the reports of the governor is a precondition. The satisfaction must be formed on the relevant materials. Recommendations of the Sarkara Commission with respect to exercise of the power under Article 356 do merit serious
Wait,
consideration.
just hold on. Come back to the page where you're showing me. Don't change the page.
296.
Yes. Yes, please continue. Subpara 2,
Subpara
isn't it?
2.
Yes.
The power conferred, are you there, Lordship?
Yes.
By Article 356 upon the President is a conditioned power. It is not an absolute power. Existence of the material which may comprise or include the reports of the governor is a precondition. Satisfaction must be formed on relevant materials. The recommendations of Sarkaria commissions with respect to exercise of the power under Article 356 do merit serious consideration at the hands of all concerned. 3. Though the power of dissolving of the Legislative Assembly can be said to be implicit in clause number 1 of Article 356, it must be held having regard to the overall constitutional scheme that the President shall exercise it only after proclamation is approved by both houses of the Parliament under clause 2, and do before such. Until such approval, the governor can only suspend the legislature's assembly by suspending the provisions of the Constitution relating to Legislative Assembly under subclause C of the clause 1, and the dissolutions of Legislative Assembly is not a matter of course. It should be restored to only when it is found necessary for achieving the purposes of the proclamation. The proclamation under clause 1 can be issued only where the situation contemplated by the clause arises. In such situation, the government has to go. There is no room for holding that the president can take over some of the provisions and powers of the state government while keeping the state government in office. There cannot be true government in one sphere. So, my lord, 4 point is that the proclamation has to be taken place only when the law specifies. That is my submission. My lord, just to counter their counter affidavit very briefly, because they have not, their main point is that
their main point is political instability,
Yes.
isn't it?
Yes. Well, look, what I would like to submit here is that the governor, having anti-defection in his mind, anti-defection law would be applicable, though it was not applicable in view of the decisions passed by this court in three cases, also followed by Meghalaya judgment also. Because the governor cannot suspend the particular MDC member. So he acted in this manner. What the law calls is that this is called colorable legislation. What cannot be done directly, the governor had done this one indirectly. This is one and the same. My lord, if you kindly see, there is judgment. Omnis moi chakma. Because, my lord, the law is very settled in the state of Mizoram, not only in state of Mizoram, in Meghalaya also, in Autonomous District Council, in 6th schedule, there cannot be anti-defection. It was held by this thing omnis.
See, so anti-defection law, so what is your point in
No, my
citing
point
this
is here
case?
that because first it comes this.
Did they say in the counter affidavit that it is because of the anti-deflection
No, my
law?
lord, they have
then?
not said that
Then?
anti-defection, but
Then?
in other language that they say that political instability.
So political instability.
Political instability.
So don't see what you feel could be the reason. Don't come into
My lord,
that.
no, my lord.
They have. So your point is that there's no
My lord.
even if there's political instability, it does not cover under 20 BB.
My lord, from
So
reading.
come to your point, huh?
No, from reading their counter affidavit, what they stated is that.
So they're saying that there's political instability.
Yes.
So you're saying there's no political instability,
Yes.
isn't it? Leave it at that.
My lord,
Why
yes, that is.
quote these judgments? Because we know the court is aware also
Yes.
regarding the anti-deflection law, whether it is applicable in the schedule, this thing.
So, my lord, reading their
basis or
counter
not. So
affidavit.
leave it at that.
Yes, reading their counter affidavit, that is their main point.
Their main point
because
is
the petitioner switched from this one before in MLA.
Nowhere did they mention that anti-deflection law is applicable and therefore this. So you don't have to
Yes,
elaborate your judgment on that point,
My
isn't
lord,
it?
but in their
Come to the
counter
point.
affidavit is that the allegation against the petitioner number one is that before he was MNF, again he switched to BJP, again he's going to switch to ZPM. That is,
Because of that, they're saying there's political instability.
Instability.
Bas, leave it at that.
yes. Then because of that, the governor took action and that passed the impugn order.
Yes.
So what my submission is that the manner how the allegation make against is that it's same with anti-defection. So he cannot take action under anti-defection law. He passed this impugn order. This is my submission. Because omnis moi after that Shreku, after that in WPC 74 2024 LR Dingliana Chinza, they are all followed. So what he cannot do directly, and action had been done indirectly, dissolving the CIDC is my submission.
Okay.
And my last point is that from their counter, annexure they have enclose some annexes, but I don't want to impugn any of the
So
annexes.
you're this thing, LR Dingliana Chingza,
Yes.
this case,
Yes.
regarding anti-defection,
before
where I
also
was
Sir
also
Poon was
sitting
also-
in the bench. So all the old, this thing where I'm involved, just
It is
citing.
admitted
Anyway,
provision.
sir, koi.
Yes, my lord, kindly go to their this one 20, it page number 24,
24 of what?
their government or counter affidavit. 25,
Page number 25.
yes.
Oh.
This is the manner how the governor can exercise for dissolutions of the autonomous district council. Exactly. And this is one of the examples cited by the government. Here, what I would like to stress is that here that the reason is that 16.2 they cited and all. Here, para 14 of the Sixth Schedule. In this
Please,
case,
read, what is this about? Oh.
my lord, this is about recruitment of the employees in Sixth Schedule. So relevant is that para 2, para 3.
Para 3, please read.
Whereas at the same time, the commission constituted under para 14 of the Sixth Schedule has submitted its report stating that in absence of recruitment rules, a number of irregularity activities have occurred in the CIDC without following proper procedures. Absence of RR itself is violations of para 268 of the Sixth Schedule, which states that there should be rule for appointment of staff of the district council. My lord, kindly see this one, para 14 and para 2. Because in that 20 BB, there are many in that list. Here is the governor can dissolve the autonomous district councils. Here, rightly, the governor pointed out in 2020, because para 14 is included in that 20 BB list. And again, para 2, see, it is also included in that list in respect of recruitment of employee without that RR. So rightly, the governor in this case passed this dissolution order. But in my case, comparing my case, in my case, the governor exercised 20 BB and 16.2 on the grounds of political instability. That political instability is absent in that 20 BB. This is my point. While that para 14 and para 2, they are present. That is the governor, and the next one, the governor relied upon this notification 15 March 2024, wherein the governor dissolved LADC. In this case also, it is not disputed that the governor rightly invoked this sub-rule to Rule 23. He has discretionary power.
So you're saying that it's different.
It's different.
This is different
Yes.
situation here.
Their
and
point is that
is
the
different.
governor can dissolve
because it's covered
the
by
LADC.
20 BB.
Yes, yes.
Okay.
But that the powers and the effects are different, entirely different. In my case, the governor has no power, has not been empowered to dissolve MADC, wherein there is no provision at all on the grounds of political instabilities. That's my point, Lordship.
Yes, Anything, any other point? That's it?
My Lord, if you can allow me to rebut the point.
Yes. Yes, Mr. Deep. I cannot hear you.
Am I audible now?
Yes, now you're audible.
Before I go into the other details, I will try to make it as short as possible. I would first of all like to refer to Annexure 11, page 43 of the petition.
Okay, page 43.
I know it might be a repetition, my lord, but this is very important. Page 43 of the petition.
Yes.
Annexure 11. Decision of the Council of Ministers
Yes.
obtained by circulation. Proposal for obtaining opinion of the Council of Ministers for imposition of governor's rule within the Chakma Autonomous District Council. As per provisions contained in Rule 15 of the Government of Mizoram, Transaction of Business Rules 2014, as amended from time to time, the above proposal of District Council and Minority Affairs Department was circulated amongst the members of the Council of Ministers. For opinion, the Council of Ministers is of the opinion that the new claimant for formation of a new council be afforded an opportunity by the government. However, my lord, there is a however. The Council of Ministers is willing to accept. This is very important, my lord. The Council of Ministers is willing to accept any decision made by the Honorable Governor, as it is a discretionary power. The Council of Ministers is mentioning that it is a discretionary power of the Governor to take action as he considers necessary. Now this, my lord, I will most humbly submit before your lordship that this has to be read along with 20 BB. Let us come to 20 BB.
Yes.
Come to 20 BB. Exercise of discretionary powers of the governor in discharge of his function. Now, my lord, I don't want to go into the details. Everything is there. Your lordship has just now gone through it. What I would like to refer to is of this schedule, shall. My lord has got it. Just 2 lines.
Yes.
2 lines from of this schedule, shall, after consulting the Council of Ministers, and if he thinks it necessary, the District Council or the Regional Council concerned take such action as he considers necessary in his discretion. Now, my lord, there is not a whisper in the Constitution or in the 6th schedule or in 20 BB that the governor has to abide by the advice of the Council of Ministers. It is a discretionary power. The aspect which relates to the advice of the Council of Ministers and thereafter the action to be taken, whether it is as per the Council of Ministers' decision, is absent. It says, take such action as he considers necessary in his discretion. That means, which has to be read, that not according to the advice of the Council of Ministers. So as far as 20 BB is concerned, it is absolutely the discretion of the governor.
Yes.
But the question whether the action of the governor is similar to that of Article 356, which was just raised by my learned friend. Now, my lord, 356 and 6th schedule should not be read together. 6th schedule is a different aspect which relates to autonomous district council and the discretionary power of the governor when it relates to 16(2) or 20 BB. But 356, my lord, in case of 356, the President of India is advised by the Council of Ministers and the President has to act as per the advice of the Council of Ministers.
Okay.
So there is a lot of difference, huge difference, when it relates to 20 BB, read with 16(2) and 356. We should not mix these two aspects.
Yes.
Absolutely a separate issue altogether. Now, my lord, the action taken on behalf of the governor, if your lordship can kindly come to my affidavit, paragraph 4, page 4, second paragraph. Paragraph 4, page
Yes.
4, second para, my lord. That
Of
the
your
constant
counter affidavit, isn't it?
counter affidavit, my lord.
Counter affidavit, yes.
Paragraph 4, page 4, paragraph 2.
Yes.
That the constant political instability is found extremely detrimental for the Chakma Autonomous District Council, as also the other Autonomous District Council, and is certainly not what is intended by the 6th schedule of the Constitution, which envisions the effective administration of the tribal areas for the interest of the people, which is certainly not what is intended in the 6th schedule of the Constitution, which means it is certainly not as per the guidelines and the provisions mentioned in the Constitution, in the interest of the people. So that was the reason that if there is a political instability, how can the Autonomous District Council serve the people's interest? There has to be a stable government. Until and unless there is a stable government, the interest of the people cannot be served. Now, my lord, I have just now pointed 20 BB, which says it is a discretionary power of the governor. The Council of Ministers, the decision by which the Council of Ministers has left it to the governor, of course, with the specific mention that they should be given an option to prove their majority. Now, whether the governor should have considered that aspect of allowing them to prove their majority as per the advice of the Council of Ministers, which is apparently mentioned. I have just now pointed. Now, whether this particular aspect being not considered by the governor is a violation of the fundamental rights of the petitioner, that needs to be considered by your lordship.
But ultimately, Mr. Dev, ultimately, the majority, that has to be seen, ultimately that's a step that has to be taken by the governor. Whether the, whichever political party, whether they have majority or not, that is the ultimate step which has to be taken anyways, as per the, what
I
was
agree.
observed by the Council of Ministers, isn't it?
I agree, my lord.
Maybe if it,
And that
even
is
if
why-
it was not done immediately.
And that is why my humble submission that the Council of Ministers has advised the governor twofolds. It's a twofold advice. One, that let them be given an opportunity to prove their majority in the House, whether they really have a majority or not, and whether they can lead the CADC and provide a
Yes.
permanent autonomous
Which
district
is the
council,
ultimate step that is required to be taken anyways.
and whether and the second option which has been given by the Council of Ministers is, as per the discretion of the governor, he can take any decision, which is there, very much there in 20 BB. If it is read with 20 BB, the discretion of the governor is very much there, irrespective of the advice given by the Council of Ministers.
Yes, okay.
Now, whether the petitioner needs to be given an option to prove his majority in the House as per the advice of the Council of Ministers, or the governor is absolutely correct in exercising his discretionary power under 16(2) read with 20 BB, that is a matter to be considered by your lordship.
Now, what are the facts that led to the to the governor to conclude that there is political instability.
My lord, there is a political.
What are the thing?
There was a change in the autonomous district council since 2023 regularly. This was happening, and there was a change in the leadership, change in the political allegiance, and one after another this was going on. If my lord can kindly come to paragraph 4.
Beginning of paragraph 4. Okay, this is
page
why
3.
the governor concluded that there is political instability, isn't it?
Paragraph 3, my lord.
Okay.
I would rather submit, my lord, that paragraph 4 from the very beginning. From the very beginning. So this was basically the reason
Okay. Yes. Okay.
why the governor came to a conclusion that there was a regular political instability and his discretionary powers should be exercised under 16(2) Red Bill 20 PP. And that is why he referred the matter to the Council of Ministers for their advice, which is very much there in the Constitution, in the 6th schedule, in 20 PP, that he has to take the advice of the Council of Ministers. Now, whether he has to act on the advice of the Council of Ministers or not, that part, the Constitution is silent on that part. But the advice of the Council of Ministers, as we read just now, there are two advice. One, to allow them to prove their majority, and second, they left it to the governor to apply his discretionary power.
Yes. Okay. I
That's
got your
all.
point.
Well, I think we can dispose of from Learned AG's submission because he submitted that.
Have you completed? Is that it? Anything else?
Let me, I have not yet completed. Now, my learned friend was referring to that fundamental right, Article 14 has been violated. I don't agree that fundamental right has been violated. The governor is very much entitled. Conclude, I would say, the governor is very much entitled. He is very much authorized by the Constitution to exercise his discretionary power. It cannot be read with 356. Here the governor enjoys a discretionary powers which he has applied under the provisions of 16(2) Red Bill 20 PP.
Okay.
And that is what he did. Now, whether it was correctly done or not, whether he should have acted on the advice of the Council of Ministers or not, that needs to be decided by your lordship. That's all there.
Okay.
Although the Constitution is silent by now.
Yes.
That's all there.
That's all. Yes.
My lord, as a secretary to the CADC,
CADC.
we don't have much. We don't have much to say, but other than the facts that has already been laid before this honorable court, but my only submission is that out of the 20 seats in the district council, the ZPM party has hold the majority of 17 seats. Yes, my lord, as of now.
So you're adopting the submissions made by the
Yes, my
learned
lord.
AG?
Yes, my lord.
AG.
Yes, my lord.
Okay.
Not just 2 points only. Because I think even Learned AG also, that he submitted that the opportunity should be given to prove their majority.
That is the advice of the
No, I have
Council of
not read that.
Ministers. Council of
That is-
Ministers
I have not
advice.
said that.
Huh.
I'm sorry. I don't agree. I don't agree with my learned friend. I have not.
No,
I have not-
so I'm
What I have
saying,
said, what I
you
have
have
said-
submitted is what the advice of the Council of Ministers is suggestion,
Exactly.
huh?
Exactly.
Not what the AG said, huh?
Yes, so opportunity be given, so that I would like to counter. And then again, and that it is admitted there have been 2 times changes, but I don't admit that there would be another change in the government. So that is, I want to make it clear that. So it is admitted.
How can you predict that?
No,
Okay,
my
I
lord, we
think-
cannot go on a prediction. So even governor also cannot pass dissolution on prediction. That is also on the oral advice of
Okay,
minister.
fine. Okay, I've heard your submissions, I think.
And also, my lord,
what,
the last point is that just to reiterate what the learned government advocate general submission is that his submission is that the governor has discretionary power in view of 20 BP, and I have read that in Milai judgment and then
Yes.
para 28 and in
That's why he's
Nabam
countering what you have said.
Yeah,
No,
that
so you
is
don't
that
have to repeat.
The government has to act on the advice of the councils of minister. It is not his discretionary power because that.
But you're missing one point, that he's saying
That is
that
applicable for
concerning
Article
the sixth
356.
schedule, it is different.
356.
Governor
That is applicable
and
for Article
president.
356. Not
Yes,
under the sixth schedule.
356.
Yes, I can say, my lord, and some of the judgment I refer 356. That is the power of the president, the governor. But the judgment I relied upon,
The latest.
the one, no, not only the latest one, Jayanta Rongpi. Rongpi, very specifically sixth schedule. Because here it is very clear, 356, all in the judgment.
So you have mentioned. No,
I have
that was-
mentioned, but just to counter submission of AG,
Yes,
that
Jayanta,
he submitted
which
that
was
the
Pandit's
power under
judgment.
356 and six schedules are
Certification
entirely
learned
different.
counsel.
But this judgment was passed by two judges. My lord, if you see this, the heading of this giant, it was passed by UL Bhatt and RK Mishra Singh.
So where's the
Division
judgment? Have you given me a
I
copy
have
of
given
that?
to you Jayanta Rongbi.
Jayanta Rongbi.
Yeah,
So
1994.
you are rebutting the submissions made by the AG, saying
AG.
that this is not correct because there is that judgment.
In
Okay,
this
leave it at
judgment
that.
clearly mentioned that in the middle of the judgment, what was that cited by Chief Justice Chandrachud, Bhagwade, it all 356 was written, cited, and in the end, it was confined to sixth schedule. Then we cannot say that they are different, entirely different, since as long as DB of this Guwahati High Court referred that 356 judgment for setting aside of the impugn notification of the President's rule proclamation. That is my point. It is not
Okay,
different.
Fine. Oh, anything else?
That,
That's it?
that's my priority. Is that
That's it, ma'am.
my last submission is that even
Okay.
in my petition also they have no specific denial that there is no provision on the grounds that political instability.
You have
I have finished. That is my last point.
you are repeating yourself over and over again. That point
That's
is
my
there.
very good point. My first point.
So you very good point, but you don't have to keep repeating it.
Yeah, that's true,
Okay,
my lord.
you-
That is
it's
my last point.
So many repetitions.
Yeah, that's
We
true.
are taking a lot of time. Yes.
Yeah, that's
Heard
my last
Mr. J.C. Lalunsanga, learned counsel for the petitioner, along with Mr. B. Deep, learned AG, Advocate General for the state respondents, and Miss
It's C. Deborah.
Deborah, learned counsel for respondent number.
I am assisted by Miss Mary Kyangte.
Yes, assisted by Miss Mary Kyangte, learned government advocate. And Miss Deborah so-and-so, learned counsel for respondent number
4.
4. Hearing concluded, matter reserved for judgment.
That's okay.
Deeply obliged.
Orders, item 6.
Yes, bail.
Yes, my lord, this is bail application. We had, your lordship had already dismissed the case before. This is the second time we'll come to it.
Okay.
However, my lord, in
What
the
are the new
last,
grounds?
my lord, 2.553 kgs of heroin, which was seized from the co-accused, and nothing was seized from his
Lipurda.
possession. And nothing was seized from his possession. And that, my lord, in the previous hearing, if I may take your lordship to Annexure 7, which is the order passed by your lordship, that, my lord, the case, we have already raised this issue, violation of section 42 and violation of article 21 and 22. That, my lord, however, in our submissions, the authority and the citations which I have relied on are not properly reflected. That here in violation of section 42,
No, don't come back to the old thing. This is done and finished. If you're not happy with this,
that,
then
my
you go
lord,
and
that on that day there was a function and the court, everyone was in a hurry. That was a function of inauguration
but
of
we
the.
can't go back to an order already passed. Okay.
Yes.
This is finished. Now you're filing a new application, bail
Yes, my lord.
application, isn't it?
Yes,
So
my
let's
lord.
come back to your new bail application and see what's this.
And
Don't
with
so
regard
hurry
to
this,
that,
where's
that, my
your
lord, the
bail
IO
application?
after this bail hearing was completed, this was in the month of April. And then after that, the case IO was called upon. If I may take your lordship to that.
Oh, yes.
At page 40.
40,
Yes, my lord. My lord, it starts from 39.
39.
My lord, this is the cross-examination, if I may read. Number 3, cross-examination by DL for accused Parul Hussain Ahmed. Number 3, in the memorandum of arrest of Parul Ahmed dated 24/9/2024, arrest information is given to Abdul Hakim Laskar, the phone number and the brother, which is the same as per the arrest memo of Abdul Majid Laskar dated 25/2023. That, my lord, the co-accused is Abdul Majid Laskar, who was arrested on 2/5/2023. And the instant applicant, Parul Hussain Ahmed, was arrested on 24/9/2024. That is after 1 year and few months. And then, my lord, arrest information is given to the same person as in Abdul Majid Laskar, who is the co-accused. And it was written in the memorandum of arrest that arrest information is given to Abdul Hakim Laskar. That, my lord, this person to whom intimation of arrest is given is not the brother of the instant applicant. And also, my lord, if I may continue reading. It is a fact that I recorded the statement of accused Abdul Majid Laskar, and it is nowhere mentioned that Abdul Majid Laskar and Parul Hussain Ahmed are brothers, both the accused. The records show that they have different fathers and different addresses. Number 5, I cannot answer to the suggestion that the arresting officer has mechanically written down the person to whom the intimation of arrest of Parul Hussain Ahmed was given as the arrest memo of Abdul Majid Laskar. That, my lord, this is also. It is number 6. It is a fact that I do not know whether the grounds of arrest and the reason of arrest was given to accused Parul Hussain or his relatives. Also, I could not produce any documents to show that such grounds of arrest was given to Parul or his relatives orally or in writing. I was not the arresting officer of Parul Hussain Ahmed, and also during that period I was posted at NCB Lucknow. And number 7, that, my lord, this is the case IO, the cross-examination of the case IO. It is a fact that I have no knowledge or documentary evidence against Parul Hussain Ahmed except the CDR corroboration, bank transaction corroboration of 8,000 between Abdul Majid Laskar and Parul Hussain, and also disclosure of name of parole as receiver of heroin in the statement of Abdul Majid Laskar. That, my lord, the only incriminating evidence against him is that there was a bank transaction of 8,000 rupees, and also from the statement of the co-accused before him, before the police, which is the NCB in this case, my lord.
What about the
which is not-
co-accused? Is he still in custody or granted bail?
He's, as far as my knowledge is concerned,
in
till
custody.
yesterday, he's still in custody.
Custody, okay. How many accused persons?
My lord, there are two.
Two, okay. Fine. And what is the stage now? Case IO has been examined, cross-examined. Then
Yes,
how
my
many
lord.
prosecution witnesses are left? Altogether, how many prosecution witnesses are here in this case? Because the case IO usually is examined at the end, isn't it? That's why I'm just asking. You're reading
No,
the
there are-
cross-examination
There
of
are, there are, this case is taken up by the Mizoram police, and then again it was handed over to the NCB, and there are a lot of witnesses. So that is, and also
because
the
the case
NCB,
IO has been examined now. It's
there
on-
are, yes, there are around 3 case IOs.
Okay.
And
So how many witnesses are still left to be examined in this case?
there are 11, my lord.
Out of 11, how many?
3 has been examined.
Okay.
And also, my
3,
lord,
so-
this takes time because there are NCB officials, they are transferred elsewhere, outside, sometimes in Mumbai, and so it takes a lot
Out
of
of
time.
11, 3.
4, my lord, including
of
the
11, 4.
yes. And also, my lord, he has been incarcerated for almost one year.
Seven numbers left.
Yes, my lord.
Okay. So you are saying that from the cross-examination of the case IO, the involvement of the instant petitioner is not proved. 3 case IOs. So this is what case IO? Because
This is
we
from
have
the
to-
NCB.
NCB
Yes, my lord.
case IO. How many? So NCB case IO cross-examination.
Yes,
You've
my
read
lord.
that out.
That is,
Then,
yes.
but there are other two case IOs still to be examined.
That, my lord, the one who submitted the charge sheet is the NCB. The arrest was, the first arrest was made by the police, the Mizoram police. So, my lord, the list of witnesses are at page 45 of my application.
45.
Yes, my lord. It's written like supervising officer oblique officer in charge. So, and there is first investigating officer, second investigating officer, and there
So
are two.
the present
yes,
one is the first investigating officer, is it? Or the second?
the second one.
Second.
The second
So
one, the
and
main
2 is
one.
still left. Huh.
The main one, because this case was handed over to the NCB. And there is the third as well, the third investigation officer. And there is fourth as well,
Oh, many case IOs, so they have to. Anyways, so,
supervising officer.
So
is
you're
there.
saying that the cross-examination.
Yes,
Okay,
my lord.
then what else?
And also, my lord, if I may take your lordship to the memorandum of arrest at page 22.
Now, did you raise this point previously, or this is the first time that you're raising this point?
Specifically, this is the first time.
First time, okay.
Yeah. Then, my lord, on this, this is arrest, memorandum of arrest. And then, my lord, if we read this, it is evident that arrest was made as per section 42 of the NDNPS Act. So that, my lord, there has to be without warrant, there has, and it was after sunset, and there has to be grounds of belief which there is no grounds of belief in this
In the memo of arrest.
by the arresting officer. Grounds of belief as per section 42, which is the mandate before making arrest. Then, my lord, in the depositions as well, in the depositions of
From where was the essay seized?
from the co-accused, Abdul Majid
From his
Laskar.
possession or what?
From his truck.
From his truck. And what were you doing in the truck? You
I
were the
was not-
driver?
No, I was not there. I was
Okay. But later,
After-
from the examination, you were said to be the rightful owner, is it?
no,
How were
because
you involved?
I sent 8,000 rupees to
Okay.
Abdul Majid. There was a transaction which we have stated in the application that was for they were both truck drivers, which is confirmed from the statement as well. They were both truck drivers, and he sent for the vehicle parts. Before that, way before the seizure of this essay.
Anyway, it's,
And that is the only incriminating statement against us. And also, my lord, another incriminating thing was that he applied for anticipatory bail, which was rejected.
Section 42, we have already mentioned previously. We have already discussed that, isn't it?
Yes, that, however,
Mandatory provisions of Section 42 in your previous bail application, if it is here enclosed, we have already discussed that. Then what is the next point?
my next point.
Then because of the money bank, I think that also in the previous bail application, that point was also considered.
Yes, my lord.
So now after that,
There was a confirmation. The only development so
case
far
IO,
is
case
case
IO.
IO. Yes.
One case IO out of
Yes.
4.
Yes.
Okay, cross-examination. Then next
Yes.
point.
And also, that regarding the 8,000, also he has stated that in
But
page
that,
40.
I think that ground was already discussed in the previous order, isn't it? It is here, para 12, 8,000, I see something like that, transferred to the account.
Yes.
So leave the points for 8,000 because this has already been discussed.
Yes,
in the
however, my lord,
previous
this
judgment,
the case IO was not examined at that time by the trial court.
So the case IO says he doesn't know anything about the
Yes,
8,000.
and that is the only one who has
one of the case IOs.
Yes, and also regarding Article 22 as well, the grounds of arrest. Also, he confirmed that in the cross-examination as well.
So Article 22 already discussed here.
Yes. However, my lord, in Article 22, my submissions of Prabir was not reflected, was not considered.
What is Prabir? So you're saying that copy, okay, a copy of grounds
Yes,
of
grounds
arrest,
of arrest.
was not given to a near relative. That's
Near
your
relative.
point. Okay.
It was given to Abdul Majid
Someone
Laskar's
else.
brother.
Okay.
So,
But
no,
not to your this thing.
yes, none
not
of my
to your
relatives were
relative.
informed.
Okay.
So they've
Okay,
just
fine.
written down whatever is written before the co-accused. And also, my lord, there is a medical.
Then medical, what's
Yes, my
wrong
lord.
with him?
That, my lord, he has some problem with the eyesight.
Eyesight.
Yes, my lord, he was referred. He was referred to a civil hospital.
Where the medical documents page?
My lord, at annexure 10, page 122.
122. Yes. So eye drops, some eye drop was given to him. Then,
Yes, my lord.
so he's getting blind or what?
Yes, my
Anything
lord.
like that?
He was.
Where is that?
He
If
was.
he's blind and cannot see, then we have to consider. But just
His
eye drop?
left eye, my lord, his left, because he cannot be admitted due to a shortage of.
Where is that he needs to be admitted? Anything? That he show me, those documents, then we can consider. Because simply his eyes, unless it's very serious, we cannot consider. But if you have a genuine case,
My lord, here is written in the first one at page 21, left eye
121,
122.
122.
Yes.
Left eye.
Yes, something with his eye and his.
Global eye drops. Eye drops. Again, number 2 is eye drops.
Yes.
So where I think the jail doctor has to examine him whether
Yes, my
he's
lord.
fit because
And
of
he
the
has to go
condition of his
to
eye. Anything from the jail
OT.
doctor or something?
Here also, my lord, is written OT Akaltor.
14 outpatient.
No, that's OPD,
Where,
not
where?
Operation
Where,
Theatre.
where?
At page 22, my lord. It's a little technical medical term, and then below that,
But then-
Monday, Wednesday.
See, because the problem with his eye, that also not both his eyes, how can you say that he's not fit to be
Yes, my
kept
lord.
in jail?
In jail, it's very difficult to give importance to just one person until unless it's like very
Okay,
urgent.
so what do you want? You want him to be referred to a medical board? We can do that.
That is there, my lord. There was already he has already been going there. However, they could not.
Anyway, so because, okay, one is his eye, very sick. Then what else?
And regarding that Article 22, and regarding that there is no chance of conviction, which is already established by, and that is why Section 37 of the Anti-NPX is not attracted. The embargo of Section 37
Okay.
is not attracted. And my lord, that he has been incarcerated for long incarceration, which is in violation of Article 21.
Do you have any authorities on that?
My lord, while we get the long incarceration, if I may submit this one application.
What is this?
My lord, this is an order passed by your lordship.
There's something regarding WhatsApp conversation. What is this?
Yes, my lord. At page 6. A perusal of arrest memo shows that grounds of arrest under Section 47 BNSS.
That is not your point. Your point is that copy was not given, isn't it?
Yes, my lord. Grounds of arrest was also not given.
So you are saying that a copy of the grounds of arrest was not given to the
Accused or his relatives.
relative.
Grounds of arrest or like the reasons of
So you
arrest.
said it was not given to the accused also in this present this thing. In your present case, grounds of arrest was not given to you or what?
No, my lord, it was not given to me at all. It was given, the prosecution had stated that it was given to Mohammed Abdul Majid Laskar's brother, who is not even my relative. They've just written like that.
No, whether brother, whoever it's given, you have to show that it was not given to you, not the relative.
Yes, my lord, in the cross-examination of the IO also, I've just read out, there also the case IO have stated that.
What? We did not give it to you.
Not given. If I may read again. At page 40, my lord, para 6.
Anyway, it's para 6. Page 40.
Yes, my lord.
I do not know whether.
Yes, my lord. Whether the grounds of arrest and reason of arrest was given to accused parole, also I could not produce any documents to show that was given to parole or his relatives orally or in writing. I was not the arresting officer. He was not the arresting officer. However, my lord, he could not produce, and none of it was given in
But
the
he was
charge
not
sheet.
the arresting officer. It's the arresting officer who will give the ground of arrest. No?
But my lord,
Anyways, that's your point. It's
yes.
okay.
Also, my lord, here in the memorandum of arrest, it said that it was given to in small letter at page 22. I have given my arrest information to Abdul Hakim Laskar 95313933436 and bracket brother, who is the brother of the co-accused, not even parole. Parole is the instant applicant.
Information is different. Then you are parole, isn't it?
Yes, my lord.
Then what is this here? Parole Hussein Ahmed, your signature here, to parole so and so. Memo of arrest, to, it's addressed to you. You are parole.
Yes, I'm parole.
Then?
My lord.
So here it is to parole. Memo
But
of
then a
arrest
copy was
to
not
parole.
even given to me.
That is happened because your signature is also here, isn't it? On the memo of arrest. Anyway, it's time for
And
lunch.
the
We'll
grounds
continue.
of arrest was, and the reasons of arrest was also not given as per the mandate of Article 22.
Okay, we'll see.
Then, my lord.
We'll have to look at this. Yes, we'll continue at 2. It's time
Yes,
for
ma'am.
lunch.
Yes, my lord.
May I seek your lordship indulgence in making a mention of item number 16 of part 2, my lord. Hearing list.
Yes.
My lord, if this matter may kindly be taken up tomorrow, if possible.
Not possible. We'll do it after the vacations now.
Immediately after the vacation.
You are there? See, because vacations, I'll be having my vacation. Then after that, we tend to forget also what was your submissions. You were not ready? Or what, for the afternoon session? Yes. On the submission made by the learned counsels for both the parties, list the matter immediately after the ensuing vacations. Yes.
Right, ma'am.
Any other mention? Yes, you can continue.
Yes, my lord, as I was saying, regarding Article 22, the grounds of arrest and the intimation was not given at all to him or to his relatives.
Okay, copy not given to him.
Yes, my lord. In support of that, I was relying on.
No, but you have to show that here in the memo of arrest, his name is there and his signature is there.
Yes, my lord. Yes,
In
if we
spite
look
of
at the
that,
memo
you
of
feel-
arrest, I have given, if I may read, my lord, in the memo of arrest, I have given my arrest information to Abdul Hakim Laskar, the brother. It's written.
No, but what is this name? Why is the signature there? In the memo of arrest, why is the signature there then?
That we don't know. My
Then
lord,
you
they
must
just
have
let them
copied it.
sign it like that. In none
Anyways,
of
you are saying it was not given, fine.
yes.
But you'll have to, but you're not, we don't know why his signature was there, because it said to so and so your name, and then you sign, okay? But you don't know why he has signed and why it was addressed to you. Okay.
And also, it has written that they have not, the prosecution needs to say that if a copy was given, a copy
So
was
was the
given.
arresting officer examined? What does he say?
Not yet, the
Then-
seizing officer.
Okay, leave it
Also,
at
my
that.
lord, here he has written, I have given. And my lord, this is exactly the same. I will take, if I may take your lordship to page arrest memo of the co-accused Abdul Majid Laskar.
No, but what I'm not understanding is on the memo of arrest, okay, your name and your signature is also there.
Yes, my lord.
When did you sign? Why did you give your signature there then?
My lord, they just let them sign. We don't know. It's their document.
Anyway, so you don't know why his signature
Yes,
was
my
there. I'll
lord.
leave it
This
at
is
that.
not my document. It's their document. If it was given, they should have mentioned that it was given, copy was served to the accused or their
To the other
relatives.
persons. Anyway, so
However-
your signature is there. That letter has been addressed to you. Okay.
Yes.
To you, so and so. And you have put your signature, but you don't know. Okay, leave it at
Yes,
that.
and copy was not given to me.
That
He
was,
was- yes.
That is what you're saying.
Yes.
But when you look at it, prima facie, straight away, I'm having my doubts because you see when a copy is given, usually they put their signature saying that they have received and it's been addressed to you. So simply you saying, I don't know where I signed it or the copy was being, it appears, prima facie when I look at it, it appears that it was given to you and you have signed against it, saying that you have received it in the original or the form which they have. But you're saying you don't know why you put your signature. So we'll leave it at that.
And
Okay.
my lord, the copy was given to his brother. It's written here.
Copy given to his brother, but then why did you sign?
That I don't know.
You
They
don't
let
know.
them
So,
cite-
so leave it at
Yes,
that. You don't know.
yes,
Just
leaving
leave it
at
at
that,
that.
yes.
Don't presume that I don't know. Just leave it. Fine.
And
then next,
another point is that
and
they've
the
given
arresting officer has also not been examined till date.
Yes.
We'll leave it at that.
and he has also given the arrest information to Abdul Hakim Laskar.
Leave it that. You have read that on and on. Leave it at that.
Yes.
We're finished.
Also, my lord, that is exactly the
So
point
I'm just
trying to
asking
make.
you one question. Why is your signature there? Say you don't know. So leave it at that. Rest you have already made your submission. We're wasting a lot of time. Next point.
Also, my lord, page 77.
Ah.
If I may take your lordship's attention to page 77. This is the arrest memo of the co-accused. And it's exactly the same. Abdul Hakim Laskar, the brother. And
So-
also, yes.
But same this thing. Caesar, same this thing has been seized, isn't it? Essay.
Yeah, nothing was seized from the applicant.
But
Yes.
from the
Same-
applicant, but
same
what was
case.
seized for the case, it is the seizure of the same articles, isn't it?
Yes, my lord.
Okay, fine.
This is the
Then-
co-accused, where all the essay was seized from the co-accused.
And
So-
copy given to him, the co-accused.
Yes.
Very good. Then next.
And yeah, mechanically given. And in support of that, I just want to rely on your lordships, and I want to invoke the doctrine of parity, as your lordship has already.
So why his co-accused was granted bail?
Yes, my lord. No.
Then parity is invoked when the
Yes, the
co-accused
co-accused,
persons are-
but they are the accused are in similar footings, my lord.
So
The same case is here. We apply bail also, and also it's a commercial
so parity.
quantity.
So his co-accused is in custody. So parity should be there. He should also be in custody. Is it?
No, my lord.
I'm just trying to understand your points.
That is also there. However, my lord, in
Okay,
this case,
that is also there. Parity. He should also be in custody. Or what? Then
that in this case also, my lord, this which is rendered by your lordship, that he was granted bail on the grounds that, if I may read page 6, a perusal which I have submitted. A perusal of the arrest memo shows that grounds of arrest under.
you're coming back to the same.
Yes, my
thing.
lord. I did
Leave
finish it at that
leave
time.
Not parity. It has to be on the same case. Leave this. Okay. If
Yes,
it's
my lord,
on the same-
however-
so is this the same FIR? No.
It's not the same FIR. Like, let me rephrase.
No, you don't
rephrase my
understand. No, I'm
submissions.
telling you, you don't understand the grounds of parity. You are citing a very different case.
Yes, my lord.
Okay.
That is why I'm
With
saying,
a
let me
different
rephrase
accused with a different
my submission.
FIR, and in this FIR, because whatever maybe grounds of arrest it was not there. Okay. So now you are trying to say that grounds of arrest has not been given to me, not on the grounds of parity. There are many judgments of the
Yes, my lord.
apex court. This grounds of parity is when two people under the same FIR.
Yes, my lord.
One
That-
accused has been granted bail. The other, under the same circumstances, have not been granted bail. You are citing a very different case with a
Yes.
different FIR and trying to cite the grounds of parity on this. No, leave it. Don't make that submission because it's nonsense. I'll tell
Yes,
you
that is
much.
why, my lord, I was asking to rephrase my submissions. That is why,
So I'm asking
if I
you,
may
if the
rely on this.
co-accused has been granted bail in this FIR, same seized articles, everything is the same, and then one co-accused has been
Yes, my
granted
lord, I
bail,
got
then you make that submission. Okay. Then your one submission was that the grounds of arrest has not been given. You have showed me the Caesar memo. You have come to the statements made by one of the case
Case IO.
IOs. Okay. So leave it. We are finished with that. Now next ground.
Next ground is, my lord, long incarceration. He's already been
yes.
incarcerated for 1 year, 1 day.
1 year, 1 day.
Yes, my lord.
1 year, 1 week. Okay.
No, yesterday. 24/9/2024, he was arrested.
Okay. So 1 year. So When was the charge sheet submitted? In
My lord,
this-
if I may read,
in your case, when was the charge sheet filed?
charge sheet was filed on there is a first charge sheet and then a supplementary charge sheet was again filed. That, my lord,
On?
we in the first charge sheet only the co-accused was there. In the supplementary, and we are the one, my lord, it was
Where
filed
you are, in your case,
in our case,
where you have been included. When was it filed?
my lord, just give me 1 minute. Eight, 15:10. My lord, it was submitted on 15:10. However, my lord, I could not exactly say the date
15/10.
when
Which year?
2024.
24.
Exactly when the court received it.
Okay, it's okay. The charge sheet was ready finally against you
At
on
page-
15/10/2024, isn't it?
Yes, at page 47, my lord.
And you have been in custody for 1 year, 1 month,
Yes, 1 year, 1 day.
1 day. Now, the judgment you have cited, you know why here no one had appeared for the respondents. So because no one had appeared for the respondents, the apex court, after 1 year, 7 months, granted bail. But there's an observation in the previous paragraph that no one had appeared for the state respondents. Anyways, yes, long incarceration, this 1 year, 7 months. Next.
My lord, regarding the long incarceration, if we may submit another 2 short citations.
This is for one is for 3.5 years,
Yes, my lord.
and the other one?
The one that I've just submitted, 1 year, 7 months.
And the other one is 2.5 years. Okay. 1 year, 7 months, 3 years, 3.5 years, and one is 2.5 years. Okay. Right. Next.
My lord, in the Dheeraj Kumar Shukla, if I may read this. It is true that the quantity recovered from the petitioner is commercial in nature, and the provisions of Section 37 of the Act may ordinarily be...
2.5 years. No need to distinct. 2.5 years. He's here for 2.5 years. no?
Yes.
So you're seeking bail on the same grounds, but yours is 1 year, 1 month, isn't it? You don't
Yes,
have to
my
read.
lord.
This court said that it's for long incarceration for 2.5 years. Okay, so Section 37 need not be considered. So same. No need to read. Next point.
Yes, my lord. And also, my lord, they have not proved the foundational facts, the prosecution. And in this case, it was recovered from here. However, my lord, we are innocent, we claim innocence till conviction. So it's slightly different. And also, my lord, this is 7 years. So, my lord, if I may, we may not.
Don't
yes.
bother. 7 years, it's not your case.
Yes, my lord.
If your case was just 1 year or something, then you have given 1 year, 7 months.
Yes, my lord.
Don't give those. It's not applicable in your
Yes,
case.
my lord. My lord, that is our main ground, since we are not allowed to raise the previous one, which was like a violation of Section 42. And we are just relying on Article 22 and long incarceration, and we pleaded innocence as there is no chance of conviction in the case, because there is no incriminating evidence against him. And also the medical. We are relying on those from four grounds. My lord, if it may be considered, and if the accused is a permanent resident of Assam. So
Of?
Assam,
Assam, not okay.
not Mizoram. So, however, my lord, the NCB, they have their hands and everything all over the states of India. So,
But his case is here, tried in Aizawl.
Yes, my
If
lord.
they are somewhere, that means you're suggesting that he will not appear if he
no, even
absconds.
if, my lord, if
Absconds
you,
or what? Why are you giving that?
My lord-
Then?
I'm just presuming that, he's not from Israel, he might abscond. So,
If
but
he might abscond also, NCB is all over, so they can
yes,
still
my lord,
arrest
their
him.
hands are very long.
So you are
We are not
sure
absconding
whether
at
he'll
all.
abscond or not.
Then, my lord, we had the chance to abscond even before the arrest, because if he wanted to, he surrender himself. If we consider on that.
Okay, enough. I've
Yes,
heard
my
you.
lord. I don't
Because
know
if you
if I.
keep talking, then you're going to destroy whatever you have already submitted. So leave it at that. Okay.
Yes, and that, my lord, if it may be, because yes. If I
Yes,
may be
okay.
allowed to rebut if
Yes,
needed.
sure.
Please, Your Lordship. Now, regarding my learned counsel submission that there is no chance of conviction, now, my lord, only 3 out of 11 has been examined. So, still a long way to go. So, it's rather premature to make the submission, Your Lordship. So, now, regarding this Section 37 doesn't come into play. It very much come into play, and that is why they themselves, my lord, come before Your Lordship now under that section. That is why that can now not be
Okay, because the bail application also
itself
is
is,
made.
yes,
Okay.
under 37. And now, actually, most of the grounds here, my land has put forth is all the ones which have already been decided by this court.
Grounds of
They are-
arrest. She's
grounds
saying
of-
that grounds of arrest was
grounds of
not
arrest
given
was-
to her.
yes. There is one very interesting case in this particular case, Your Lordship. It's a very strange one. The story goes like this. Actually, the SAC's article was seized from one truck, bearing number so from the co-accused man. It was code red-handed from his truck, way up in somewhere. I couldn't just say right now the location, and it was seized from his book. And he himself stated that that doesn't belong to him. It belongs to the present petition. And on asking how, and he presented the phone call also. And later on further investigation, it was found out that a sum of, as my learned friend has submitted, 8,000 rupees was transferred to him for price payment of that seized article also. And that is why, my lord, after that was happening way back on 2nd of May 2023, lord, that initial arrest and recovery. And on further investigation and going through all the call records, my lord, call records, and it was found that he seems to be actually involved. So he was summoned to appear before the court, my lord, but he declined. That already everything, my lord, I think I have
It's
already
there.
submitted in the
Okay.
other bail application also at para 8, my lord. It's reflected there in that. Warrant of arrest after he failed to appear before the court. Warrant of arrest was issued 2 times. First was on 30th of January 24, my lord. 2024, warrant of arrest was issued against him. And again, since he could not be apprehended due to one reason or another, another warrant of arrest was again issued on 15th of May 2024, Lordship. And then thereafter, the that warrant of arrest could not be executed, my lord. Then they traced out the location and his residence down there in Kachar, my lord, by the NCB people. But he luckily escaped. My lord. He actually ran
That's
away.
why the counsel for the petition is having apprehension that he
Yes,
might abscond.
yes,
But
yes,
NCB is everywhere. Huh.
Yes, that
Because he had
he ran
escaped
away
there.
and he couldn't be arrested by the NCB people, my lord. Then, instead of surrendering to the NCB people, he himself come before this court, my lord, applying for anticipatory bail, my lord. But that anticipatory bail was dismissed by this honorable court. And this court, through counsel, advised him to surrender before the learned trial court, my lord. Thereafter, accordingly, having no other option, my lord, he surrendered to the court. That was on 18/9/2024, my lord. He surrendered before the trial court, my lord. He himself, it was not arrest also. On the strength of warrant of arrest issued against him, he surrendered to the trial court, my lord. And at that time, he was also not in the hands of the NCB, my lord. And he was remanded into the central jail, my lord. And then on being arrested, then the NCB people, my lord, went down to central jail and interrogated him about his involvement. Therein, my lord, his statement was also as per court permission, my lord, of the trial court. His statement
Anyway,
was also
whatever
recorded, my lord.
statements he make, that
Yes,
we will
yes,
have,
yes.
we can't
Anyway, my lord,
use
anyway,
that.
let that be, my lord. Then, his official formal arrest was made only on 24th of September last year, my lord, 2024, at 5 p.m.
Oh.
So that was the circumstances under which he was arrested. So actually, mechanical application of this citation my learned friend has tried to rely on could not apply in this case.
Because he had surrendered.
Number
Okay.
one, yes.
Oh.
Number two, he also himself signed it there, my lord, saying that he received copy, my lord.
So her memo, that's what now I'm trying to figure out why
Yes,
is
my lord.
his signature.
Actually, my lord,
Just let's come back to the memo of arrest because he has to have the copy. Page. What was the page memo of arrest? Why did
Page
he put
22.
22. Because that's one point I'm a bit concerned with. The other says medical and all. I don't think it's very serious. You see, because if he was not, memo of arrest. Here, it is signed on
24/9.
24/9. He was, a formal arrest was made on 24/9.
24/9.
And he has signed on the memo of arrest on 24/9.
Yes, it was.
So, and then the memo of arrest mentions the sections.
My lord, yes. And actually, my lord, now the principle behind this recent judgment from the apex court saying that they have to be supplied written ground of arrest, my lord, comes from the circumstances under which accused have been arrested, my lord. In such case, that when they are in peaceful circumstances, having no suspicion of being arrested or having any ground to run away, my lord, they
Okay, he knew because he had applied
Actually,
for
yes, my lord.
anticipatory bail. Okay.
he himself ran away on being asked to appear before the court, my lord. That also he did not comply. And he very much knew the reason for all these processes being made against him, my lord.
And on the memo of arrest, he
Yes,
signed
and
on
that also he
24/9/2024.
So actually, there cannot be any mechanical application of that judgment of the apex court in his case, my lord.
Anyways, continue.
So I think that already also in the earlier application, my lord, been decided, my lord. So I think it's there is no fresh ground here regarding that issue also.
Okay, in the previous bail application which
Bail
was
application,
rejected
yes.
by this court, the same points was grounds was given,
My lord, yes.
taken or what?
That-
Okay, but now it's been considered afresh because of the examination of the second case IO.
Yes, second, yes.
She has taken, this same ground has been taken now because on the examination of the second, cross-examination of the second case IO.
Second IO. yes.
Huh.
Now,
Some
first
things were
IO is
mentioned.
there also.
Okay, fine.
So as far as I know, my lord, till now have also not been examined. And
The
the most
arresting,
important,
the arresting officer has not been examined.
seizing
Ah,
officer will be the important one regarding this issue. also.
Okay.
So that also still left out. So we'll still have to wait for that also.
Okay,
to
next.
see into this.
Then
issue.
what is the other ground?
So that-
Medical.
Medical,
Next is medical.
yes, Lordship. If I may take Lordship through all the medical documents, 122, page number 122. Actually, I failed to see, my lord, any serious ailments or illness suffered by the applicant herein, my lord. Actually, what they have also prescribed is only eye drops. And
Not too,
here
just
also,
looking at it doesn't seem too serious.
there is one vernacular noting down here.
Ointment. Ah.
Follow-up advice, man. Phone khoi claim tour, muttam tour, like this, man.
Oh, okay.
Here on the left side of
Where,
that
where? Oh, okay.
page 122, man. Those are the only
Follow-up,
advice.
follow-up advice is phone ko itam, claim to, and muttam to.
Yes. So I.
So let him follow this follow-up advice, and then if his eye condition gets worse in spite of this, maybe we can consider, isn't it? Huh. Yes, next.
Had there been any serious medical condition, my lord, I very much understand.
Oh,
that.
yes, we
But
missed
now,
this out. Huh. Yes, then.
I think there is no medical
That-
ground serious enough to warrant release on bail, my lord.
Then long incarceration.
Long incarceration, my lord. Now, the present accusation under commercial quantity is the maximum punishment is 20 years with fine of 1 lakh to 2 lakhs, my lord. Not less than 1 lakh. So, considering that punishment which is to be met out to any found guilty, my lord, I think only 1 year is a little too less. And that, my lord, depends on how trial will go on and how will be maybe convicted. If convicted, my lord, then. And that, why I say, my lord, because now in terms of section 54 of Indian PS Act, my lord, there is reverse burden of proof lying now on the applicant herein, my lord. He will first have to prove his innocence. Until and unless that is proved, my lord, he is presumed to be guilty, my lord. So,
If they establish this thing, if it's from their possession, no, then. But this seized article was not seized from his possession.
but there is constructive possession in also. Not even if it's not a physical possession, it is a constructive possession wherein the applicant herein has control over the seized article, even though not in his physical possession.
Okay,
Since he
fine.
paid for the price. So that is
That
the
has
sum and
been
substance of
proved.
my
Ah,
submission. in
okay. That's it. Anything in rebuttal?
Yes, my lord. The learned PP had said, has made a submissions on presumption in he cannot prove anything, even though the
Okay.
charge sheet is already there. So the law is the law which mandates that.
Okay, fine. Heard Miss Lalgai Sake, learned counsel for the Lalgai Sake Fana, okay, learned counsel for the applicant / petitioner, along with Mr. Caesar Ramchana, learned counsel, standing counsel for the opposite parties. Yes, I'll pass the order. It will be out by tomorrow.
Obliged.
Bye-bye.
Item 7.
Yes.
Yes, Lordship. Lordship, this is an application for condonation of delay.
Oh, how many days?
Lordship, there has been a total number of 1,883 days delay in filing the connected appeal.
Why so many days? What are the reasons given?
Your Lordship, the reason I have stated under
In para?
page number 3 of the
Yes.
application. Your Lordship, the appeal was filed against the judgment and order passed by the trial court in eviction suit, and that order was passed on 26/2/2023.
26 to 2023,
2020, Your Lordship.
2020.
Yes, 26/2/20.
Ah,
And that order was passed ex parte.
oh. Okay.
So since the order was passed ex parte, it was not known to them immediately. And as such, no step could not be taken immediately. Moreover, at the relevant time, no proper step could be taken due to COVID-19 pandemic. And after obtaining knowledge of the said order, the appellants were advised by their counsel to prefer a review petition. Accordingly, a review petition was filed on
Okay,
9.
mortgage means then the property in question was been mortgaged. What did you say just now? When you got to know about the ex parte order, you were advised, is it?
Yes. Your Lordship, since they were directed to vacate their residence.
Okay, there was an order to, okay, when was this?
Uh, Your Lordship,
Any date?
they cannot specify the
Okay,
exact date.
okay, around what time?
But a review was filed on 9/3/2021.
Okay, 19?
9/3/2021.
Review. Oh,
Yes, Your
okay.
Lordship. Review petition number 8 of 2021. And that review petition was dismissed
Dismissed on?
8/4/2022. Because the learned trial court was of the opinion that there was no error apparent on the face of record.
Okay.
Your Lordship, thereafter, an RFA was filed, RFA 20 of 2022, before the district judge High Hall. But the RFA was dismissed on the ground that the learned district judge has no pecuniary jurisdiction.
Okay, date of dismissal?
18/8/2022.
Okay.
That regarding that thing, by filing the RFA, there was a delay, and that at the time of hearing of that delay application, the RFA was dismissed. And thereafter, an application under Order 9 Rule 13 CPC was again submitted, which was again dismissed on 13/7/2023.
On when?
13/7/2023.
7. Okay.
So, Your Lordship, in this regard, what I would like to submit is that the appellants were not having any knowledge of court proceedings, and as such, they were completely depending upon their counsel. And however, no advice was given by their counsel to file an appeal before the High Court, and instead, their counsel preferred to contest the execution case, which was filed for execution of the judgment and order 26/2/20. In fact, even if the applicant were advised to file an appeal before the High Court, they will not spend that time. Since
Okay, it was dismissed on 13/07/2023, isn't it? Then after that,
yes,
the instant this thing, is
yes,
it? Oh.
that application was disposed on 13/3/2023.
I thought you said 13/7.
13/7, yes. 13-7.
2023, huh? Then what is this execution case now?
Then the execution case was
Filed.
the execution case was filed in the year 2020.
Okay, that's when they were directed to vacate their residence.
Yes.
Okay.
There are, as per, thereafter, they were directed again to vacate the residence, the suit property. So before that order was passed, they were not aware of the necessity of filing an appeal before this Honorable High Court.
But they had approached the different forum by filing
Yes.
an RFA, isn't
Yes.
it? Then
After filing an RFA, an application under Order 9, Rule 13 was submitted, which was again dismissed. And thereafter, they blindly depend upon their counsel. Though that their counsel did not advise them to file any appeal. Instead, the counsel pursued the execution case by contesting the that execution case. But since no appeal was filed, there is no chance of winning the case.
how
So
did they okay, so where's this thing? Execution case, contesting the execution case. Anything? Nothing is here.
then thereafter, they were again directed to vacate the suit land.
They were directed to?
They were again directed to vacate the suit land with the assistance of the police force on 3/6/2025. So they were forcefully evicted. They were evicted with the assistance of the police force from their house, and their house were kept under lock and key, and as such, they were to stay outside their house since 3/6/2025 till then. So only since 3/6/2025 that the appellants were aware that it was necessary to file an appeal before the High Court. So they immediately consult another counsel. So as a result, they were advised to file an appeal before. They were advised that it is necessary to file an appeal before the High Court. So steps were taken to file an appeal before the High Court. So in the process,
Where they connected by this thing, RFA? This is the IA. Okay, yes, it's here. Now in the RFA, just to see, is it against only the ex parte order? Must be a civil suit or something. I don't know. What was the first one? Ex parte order was in what which case? Civil suit, is it?
eviction suit, Your Lordship.
Eviction suit.
Eviction suit number 4 of 2019.
So the appeal is against the eviction suit. Okay.
Yes, Your Lordship.
And ex parte? No, the execution case is registered as?
In the year 2020, execution case number 52 of 2020.
Hmm. 52 of 2020. So the instant appeal is against both eviction suit and execution case, is
Yes,
it?
yes, Your Lordship. And
Yes.
yes, Your Lordship. Your Lordship, in this regard, I would like to submit this judgment, that is suo motu of the PPC number 3 of 2020.
what the pandemic, this thing, during the COVID. This covers the period between,
Yeah, Your Lordship.
which is the period to be covered, 15/3/2020
Yes.
till
That is at page number 4, Your Lordship.
28
28 to 2022.
2022.
Your Lordship, as per Roman number 3, in cases where the limitation would have expired during the period between 15/3/2020 till
So-
28/2/2022.
So in your case,
Yes.
the impugned order is 20/2/2020, isn't it?
Yes, Your Lordship.
So limitation period would be, so you're saying this is covered up to 28/02/2022. So how many days is that?
Your Lordship, that
Just
as per
calculate.
that order, that limitation period, all persons shall have a limitation period of 90 days, counting from 1st March 2022. That means that limitation will extend up to 30th of May 2022.
Okay. So in your case,
Yes, in my case, Your Lordship, considering the extension of the limitation period directed by the Apex Court as per the said judgment, the total number of delays in the instant appeal shall be 1,149 days. That is, counting from 30/5/2022 till 22/7/2025. That is the exact date of filing this appeal.
from 35/2022 till,
Till 22/7/2025. The instant appeal was filed in 22/7/2025.
so how many days?
1,149 days.
You have applied, in your application, for how many days have you applied? For 1,883 days.
Yes,
Because
that's
from the
counting.
date of the order.
Yes.
Okay. So actual delay is for, it's still a lot.
Yes.
1,149 days.
49 days, Your Lordship. Then, Your Lordship,
So
and-
you have to explain after 30/05,
Yes, Your Lordship.
2022, what did you do?
Thereafter, Your Lordship, that mention may be made in this regard that a review petition was already disposed of within the COVID-19 extension of limitation period. And thereafter, after the review petition was dismissed, an RFA was filed. RFA was filed, which was disposed of due to lack of jurisdiction. And thereafter, an application under Order 9, Rule 13 was again filed. That application was also dismissed on 13/7/2023. Hence, in the process, a number of 409 days delay have been caused for filing that RFA.
Okay, so between this period, how many days?
There has been a total number of 409 days.
409 days.
Yes, Your Lordship.
So that is as per the Limitation Act, some other, when the matter is pending in some other court, isn't
Yes,
it?
yes.
Section what? Section?
Section 14, Your Lordship.
14, isn't
Yes.
it? Huh?
Yes, as per
So
the.
409 days. Okay, that is explained. You had
Yes.
gone to a different court.
Okay.
Then, after that,
After that, Your Lordship, the counsel of the applicants, that is the previous counsel, the previous counsel of the applicants preferred to contest the execution case, which was filed by the opposite party, respondent number 1, for execution of the judgment and order dated 26/2/2020. In this regard, it is submitted that the applicant.
How
at
did
the-
he contest? Did he file any objection, anything? You have
No,
to show how he contested. How did he appear before the?
they appear. That counsel just appear and make some prayer on behalf
So
of the
Where's
applicant.
the order sheet that he's been pursuing the matter in the eviction execution case? That you have to show those documents. There must be a file showing execution case number 52/2024, isn't it? Now, in that execution case, you have to show how he has appeared, etc. That is there, not there.
My lord, the execution case has not been challenged at all, in fact, in the main appeal. It's only the CMA application in the eviction suit which have been challenged, as well as the impinging order.
That's why I'm asking him, how is the execution? You're saying that he was pursuing the execution case, then you have to show now how the council has been
That's
pursuing
that
the
thing, Your
execution.
Lordship. And unfortunately, we have not submitted any document in this regard.
So you want time to submit documents?
If I
We'll
may
give
be
you a
allowed,
chance, we'll
yes.
let him submit additional documents too, so that he can substantiate his submission, isn't it? Then we'll see us some other day. Because simply making a submission without some documentary evidence to show that the matter was being still proceeding, some things are done, that you have to show.
Yes, Your Lordship.
Yes, we'll fix some other date.
Well, my lord, he has not challenged the execution case at all in his.
That's what you're submitting, but
So
he's
he wa-
saying
he-
he was
he'll have to amend
pursuing.
it.
Pardon?
He'll have to amend his entire RFA.
But then in his submission, not in the RFA,
No, in the RFA also he has not challenged anything.
but
regarding the
whatever, he said that he has, the RFA we're not going to consider now. Now he's giving his grounds for his delay.
Yes, ma'am.
Delay, one of his grounds he's taken was that instead of filing the RFA, the council had pursued the execution case. Okay, so he has to show how he has been pursuing the matter in the execution case for which he has no documents. This thing should be there, order in the court showing that he was present and he submits that. Something should be there.
Yes.
He has to show that, otherwise he has to explain the delay between after the last order, that is 13/07/2023, when the matter was dismissed. An order was when an application was made under Order 9, Rule
Yes, Your
13. That was dismissed on 13/07/2023. After that, he has been pursuing the execution case. That has to be shown, for which he's paying time to get some documents from the execution case record, most probably.
Yes, ma'am.
So you let him do his homework.
Yes,
But, my
Your
lord,
Lordship.
there's no stay in the execution case, and there's an order allowing giving liberty to the respondent number 1 to demolish the structures right now.
That's
So-
for him to submit.
Yes, my lord. And he's not
He's
rushing
not-
the.
he's not
Your
pressing
Lordship,
that
since
on the-
uh,
We'll listen immediately after the vacation.
yes,
Okay, let's see. Anyways, that's here. It's for the appellant to
Yes, ma'am.
raise those points. If you have not raised it, leave it. It's in your favor then.
Yes, ma'am.
Anyway, I heard Mr. K. Lal Dinglian, learned counsel for the applicant/appellant, along with Mr. Rosan Swal Ralte, learned counsel for respondent number 1. After hearing, on hearing the submissions made by the learned counsel for the applicant, the learned counsel for the applicant is allowed to produce certain documents to substantiate his claim that the learned counsel for the applicant had been pursuing the matter in the execution case number. What is the number?
52 of 2020.
52 of
52 of 2020.
2020. Accordingly, this court find it appropriate to give a chance to the learned counsel for the applicant to produce the documents to substantiate his above claim by filing an additional affidavit. Okay. list the matter immediately after the ensuing publications.
Yes, Your Lordship.
My Lord, 9th October, possible.
My Lordship,
Okay, oh, you want a date?
my
Huh?
Lord, 9th
It's on.
yes.
What? What if you want a date?
Yeah.
Okay. Immediately after dinner on, huh?
9th October.
Yes.
Okay, 9th, 10, 20, 25.
Your Lordship, can I have a mention on behalf of Mr. Lauren Pluanga regarding
Who's Lalram Plonga? For what?
Mr. Lauren Pluanga
For
regarding part 2, item number 3, because he has a low BP last night, so he's unable to come. So he requested me to make a prayer to fix that
item
item.
number 9.
3.
Item number 3.
Part 2, item number 3.
But he's the what? Petitioner or appellant? What?
I think he's a.
Okay, come back to this thing. Find out. Then the consent of the other side has to be taken also. It's going to be still this thing listed tomorrow. So find out by tomorrow.
Okay, yeah.
You can make a mention on his behalf tomorrow
Yes.
by informing the other side also. Isn't it?